How long will it take to get all this in to start already?
No problem. You missed the swearing in of the court reporter. It was touching. There were tears. I'll give you a minute to get settled. Okay, are we settled? Thank you.
I think we've done something. Yeah, I would be on.
You know, work instructional power, specifically talking about that.
That's right. Got it out of your system. Thank you. Can we have council appearances, please?
Hamilton Fox and Jason Harrell for the Office of Disciplinary Counsel.
Good morning, Mr. Fox, Mr. Burrell.
Harry McNichol and Charles Burnham for the respondent, Jeffrey Clark.
Good morning, Mr. McDougall, Mr. Burnham, and I understand Mr. Destro is with us remotely.
Correct.
Good morning, Mr. Destro.
Good morning, Mr. Hirsch.
Before we get started, I just want to remind everyone to speak into the microphone so that all of us that are remote can hear you.
Thank you. Can you hear me okay?
Yes, you sound great. Thank you.
Oh, great. I'm not so sure, but okay. This matter is before a hearing committee pursuant to Rule 11 of the District of Columbia Court of Appeals, governing the District of Columbia. I am Merrill Hirsch, Chair of Hearing Committee number 12, and with me are the other members of the committee, Rebecca Smith and Patricia Matthews. This hearing will be an adversary proceeding, and it's part of the process to determine whether discipline should be imposed upon Mr. Clark. All proceedings before the hearing committee shall be open to the public, and this hearing will be live streamed for public access on YouTube. In this proceeding, the witnesses will be examined under oath or affirmation. At this time, I would like to remind the parties that they are required to keep track of the exhibits that are admitted, excluded, and not introduced into evidence over the course of the hearing. Prior to the end of the hearing, both parties will need to confer and sign final lists indicating the status of each exhibit using the exhibit list forms that they filed before the hearing. If the parties disagree as to the disposition of any exhibit, that disagreement must be raised with the hearing committee before the end of the hearing so that it may be resolved before the end of the hearing. Those signed lists should be filed with the board office upon conclusion of the hearing. All right, with that, I'd like to begin. Mr. Fox, do you wish to give an opening argument or opening statement?
I do. This mic is live.
I believe so, but you might want to move it a little closer.
Yeah, can you bring the black mic closer to you, please? Thank you.
Just one housekeeping matter before we begin. I want to let respondents know the lineup, as it were, of witnesses. We're going to begin with Mr. Donahue, who is here. Mr. Philbin, we have available this afternoon. Will be remote. He's on vacation with his family in St. Croix. We have Mr. Rosen scheduled to begin first thing tomorrow morning. It is not clear to me yet whether Mr. Rosen will be live or remote. I hope live, but we will see. I hadn't heard back from his lawyer when I came over to this. And then we have to have Mr. Counsel after that. We will not be calling this matter for. We will be calling Mr. Clark at some point, and that will either be at the end, or if we happen to have a hiatus, we'll fill in there. I would anticipate that we will have our case completed by the close of business tomorrow, possibly going over Thursday morning. I would request that the respondents give us 24 hours notice of the names of the witnesses who are going to be available, so that we don't have to log all the files back and forth each day. And that is all I have with housekeeping.
We're happy to do that. I also want to propose that.
All right.
And I appreciate the, line.
All right, thank you. Then please do.
If there's nothing further, I'll immediately
Please
say.
proceed.
In 2020, certainly for the first time after the Civil War, and probably for the first time in history, presidential candidate refused to accept the results of the election and acquiesce to the will of the people, and therefore launched a series of efforts to undermine the integrity of that election. I'm sorry to say that in some of these efforts, he was aided by lawyers. And one of those lawyers was Jeffrey Clark. President Trump attempted to use the Department of Justice announced that the department would
Could all right, we take a pause for a moment. If there are additional materials, you can leave them outside of the door for now so we don't interrupt the proceeding. Appreciate it. Thank you. Please proceed, Mr. Fox.
Shortly after the election, Attorney General Barr announced that the department would begin to investigate allegations of election fraud at an earlier time than it had traditionally done so. Traditionally, the department's position was that it waited until after the results of the election were certified before it would investigate these allegations in order not to be accused of interfering with the investigation. But the Attorney General decided that they would initiate the investigations as the allegations came due. This was a somewhat controversial decision that he made, but in hindsight, it proved prescient. Because with 94 U.S. attorneys, plus the assistant U.S. attorneys that work for them, FBI agents, members of the Public Integrity Section of Main Justice, they were able to investigate quickly these investigations. And when subsequently people claimed that the election had been procured by fraud, they were able to respond to those allegations. The person in the Department of Justice who headed up this operation was Richard Donahue. Richard Donahue was the principal deputy to the Deputy Attorney General. I apologize for getting deputies too mixed up there. That's sort of the way of the bureaucracy. I think his title was actually associate. But anyhow, he was the principal guy that Jeffrey Rosen, who was then the Deputy Attorney General, relied on. And Mr. Donahue is an extremely experienced prosecutor. He had been the United States Attorney for the Eastern District of New York. And all of these investigations nationwide flowed through Mr. Donahue. He was, in fact, the most knowledgeable person in the Department of Justice, indeed in the country, as to the status of the federal investigations into election fraud. And he regularly kept Mr. Rosen, his boss, the deputy attorney, and Attorney General Barr apprised of the status of these investigations. Indeed, he spoke with them virtually on a daily basis about them. Now, one lawyer who was not in the loop was Jeffrey Clark. Jeffrey Clark is an environmental lawyer who had been appointed to be the head of the Environmental and Natural Resources Division at the department. In September of 2020, because of a resignation, he became the acting head of the Civil Division. But the Civil Division played no role in the investigations that were conducted after the election. There was some litigation they had to defend, but in the actual investigations, they played no role. That role was played by the Criminal Division, Civil Rights Division, Civil Division, and specifically Jeffrey Clark had no role. As the weeks wore on, it became apparent that none of the allegations of election fraud were proven to be significant. And on December 1 of 2020, Attorney General Barr said so. He said that there had been the investigation had produced no evidence of any kind of fraud that could have had any effect on the outcome of the presidential election. This was not a happy revelation to the president, involved as he was with attempts to discredit the election. And in December, Mr. Barr announced that he was resigning as Attorney General effective December 23. There was another thing that happened of significance in December, on December 14, and that was the Electoral College vote was taken. And that vote, let me get my numbers here correct, that vote resulted in Biden winning the election 306 to 232. The other significant development in September was that shortly before he resigned, I think 2 days before he resigned, Attorney General Barr repeated in a press conference that there had been no evidence that developed of any election fraud that could have affected the outcome of the presidential election. After Attorney General Barr announced his resignation, the president designated Mr. Rosen to be the acting attorney general upon Mr. Barr's departure. So the designation preceded the time in which Mr. Rosen actually became an acting attorney general. You might think that the deputy attorney general would automatically become the acting attorney general, but that's not necessarily the case. But at any rate, Rosen was going to take over as acting attorney general on the 23rd when Barr departed. And Mr. Donahue's title was not going to change, but he was going to serve in the position as effectively as the deputy attorney general. So they would be the number one and the number two people in the Department of Justice for the remainder of the administration. Starting in mid-December and going on for several weeks, the president had a number of conversations with Mr. Rosen and Mr. Donahue, in which he raised various allegations about supposed fraudulent conduct in the election. And in virtually all of these instances, because Mr. Donahue was the most knowledgeable person, Mr. Donahue, to some extent Mr. Rosen, were able to say to the president, we've looked into that, there's nothing to it. On the rare instance when the president mentioned something they hadn't heard before, they said they would look into it. They tasked the relevant assistant the relevant United States attorney to look into it and reported back that there was nothing there. Towards the end of December, they began to hear from the White House the name of Jeffrey Clark. And specifically on the 24th of December, Christmas Eve, the president, in a conversation with them, said that people have been telling him that he ought to make Jeffrey Clark in charge of this investigation. Now, this was a puzzlement to Mr. Rosen and to Mr. Donahue, because Mr. Clark had no involvement in the investigation. The Civil Division had no involvement in the investigation. And Mr. Clark had no apparent expertise in any sort of criminal investigation. He was an environmental. On the 26th of December, Mr. Rosen spoke with Mr. Clark to try to find out why it was that he was hearing Mr. Clark's name in this context. And Mr. Clark told him that he, Mr. Clark, had met with the president in the Oval Office and discussed these matters. This came as a considerable surprise to Mr. Rosen, and it was a violation of the procedures that the Department of Justice had in effect with respect to White House contacts. Ever since the Watergate days, there have been restrictions on the contacts between the White House and the Department of Justice. And people at certain levels are allowed to have contacts, others aren't. Mr. Clark was not one of those people. And it's not just that he had had contacts, but he had never informed his superiors that he had been in contact with the White House, specifically with the president. That discussion occurred, as I said, on December 26th. That was a Saturday. The next day, December 27th, was a Sunday. And on that day, as he had done on several other occasions, the president called Mr. Rosen to talk about these various election allegations. There were two calls, and on the second call, Mr. Rosen conferenced in Mr. Donahue, who was in New York. That's where his home is, in New York. And the call lasted for probably an hour and a half. Mr. Donahue took some notes. He didn't take down everything. But it was, again, the same tenor. What about this? What about that? For example, the president raised an allegation in this call, I believe it was, about whether there had been more votes counted in Pennsylvania than had been cast, which was a new one for Mr. Donahue, and he looked into it and found out that it wasn't so. At any rate, at the end of this lengthy conversation, the president said people were telling him that he ought to replace the leadership of the department and put Jeffrey Clark in charge. Later that same evening, Mr. Donahue received a call from Congressman Perry, Congressman from Pennsylvania, who also said that the president was very interested in having Mr. Clark in charge of this investigation. Mr. Donahue actually received that call while he was driving, although he wasn't personally behind the wheel, back to the District of Columbia from New York. The next day was a Monday, December 28th. And on that day, Monday, December 28th, Mr. Clark asked to meet with Mr. Rosen, and they arranged for a meeting at 6 o'clock at the end of the day. At 4:40 in the afternoon, Mr. Clark sent Mr. Rosen and Mr. Donahue an email with a draft letter attached. And that is Exhibit 8, Disciplinary Counsel Exhibit 8, and that is at the center of the case. And I'm going to ask that be put up. I'm not going to spend any time on the first page of this document, which is the email, other than to say that it discussed some kind of crazy internet theory that the Dominion election machines had some kind of internet connection through an automatic thermostat that was manipulated in China. And Mr. Rosen asked for a briefing from the Director of National Intelligence. But he also proposed that the attached letter, and if we could go to the second page, be sent by Mr. Rosen, Mr. Donahue, and Mr. Clark. We just describe the letter in summary form, and then we'll look at some aspects of it. Essentially, what this letter asked was that the Department of Justice write various officials in Georgia and seek to have the Georgia legislature, which is called the Georgia Assembly, seek to have that legislature called into special session at which it would, not totally clear what it's supposed to do, but apparently it would select an alternative set of electors who would vote for President Trump. Georgia had certified the election results, and its electors had voted on December 14th at the Electoral College for Biden. This was to create an alternative set of electors. That was the thrust of the letter. There were two serious problems with this letter. The first serious problem was that it contained false statements of fact. The most significant of which is on the first page, and if we could just maybe make that a little larger, the first part of the first paragraph, Emily. There's a sentence here that says, at this time we have identified significant, mine's a little off center. Maybe just a little smaller, perhaps. That's it. At this time, we've identified significant concerns that may have impacted the outcome of the election in multiple states, including the state of Georgia. That sentence is not true. And Mr. Donahue and Mr. Rosen knew it was not true. The Attorney General Barr had already twice made public statements to the contrary. Mr. Donahue was the most knowledgeable person about what the results of these investigations were, and they did not produce significant concerns that may have impacted the outcome of the election in multiple states, including Georgia. It was simply not true. And Mr. Donahue immediately told Mr. Rosen that. He sent an email, which you'll see later on, which told Mr. Rosen, Mr. Donahue told Mr. Clark that. Sent him an email which told him that. The second problematic aspect of this can be found on pages 2 and 3. Let's look at page 2 first. And if we could look at the first paragraph, Emily. And what you'll see here is that what Mr. Clark is proposing is that the department tell Georgia convene a special session and to essentially conduct a trial to take additional testimony, receive new evidence, and deliberate on the matter consistent with its duties under the Constitution. Now, before this had ever been written, the governor of Georgia had announced that there was no legal way in Georgia to call the legislature into special session. And he had said that if you did that, the result would be very, very serious litigation. So that could not be done. So, and then the purpose of all this, and now let's go to the third page. And here I think we want to look at the last paragraph. And you can see that the thrust of the last paragraph here is that at the special session of the legislature, for the limited purpose of considering issues pertaining to the appointment of presidential electors. Now, this paragraph is perhaps not complete, but the thrust of the letter was that a new set of presidential electors should be delegated. And of course, had that happened, the result would be chaos. Chaos for the Georgia legislature, chaos for the Congress of the United States, because on January 6th, as we all now know, the Congress was supposed to confirm the results of the election. Chaos for the courts for the ensuing litigation that would inevitably have occurred, and chaos for the stability of the political system in the United States. Thank you. At 6 o'clock, a meeting was convened in the Department of Justice between Mr. Clark, Mr. Rose, and Mr. Donahue to discuss Clark's proposal. And in that meeting, Mr. Donahue and Mr. Rosen told Mr. Clark in no uncertain terms that there was no factual support for his claim that these allegations may have had an effect on the outcome of the election, and that it was not the role of the Department of Justice to engage in the conduct that Mr. Clark wanted them to do so. They also reiterated to him the rules about White House contacts. Mr. Clark seemed at this meeting to accept what they told him, accept that there were no such allegations, and promised that he would adhere to the rules with respect to White House contacts going forward, and certainly would let them know if anything like that happened. And so they left the meeting with the belief that this issue had been resolved. Now, if it had been resolved at that meeting, we would not be here today. Mr. Clark's lawyers have said in a number of pleadings that it's not a violation of the disciplinary rules to come up with a bad idea. We've all had stupid ideas. But it did not end with this meeting. Because despite what his superiors had told him, the people most knowledgeable about the conduct of these investigations, Mr. Clark persisted, and as you will see, eventually engaged in coercive tactics to get this letter sent. Although they thought they had put the issue behind them, Mr. Rosen and Mr. Donahue began to get more signals from the White House that there was an interest in having Mr. Clark involved in these election issues. As a result of that, Mr. Rosen authorized Mr. Clark to get a briefing from a national intelligence briefing. You remember I mentioned before, there was this crazy internet rumor about the Dominion machines being manipulated through some kind of thermostat. And Mr. Clark had asked for a briefing, and so Mr. Rosen authorized that. And he also told Mr. Clark, he directed Mr. Clark to telephone the United States Attorney in the Northern District of Georgia, a fellow named Pack, P-A-K, who was the person who was on the ground in charge of all the investigations in Georgia. And when he checked back with Mr. Clark, he found out, Mr. Rosen found out, that Mr. Clark had gotten the national intelligence briefing and was pretty much off the issue as to whether there had been any foreign intervention in the election. But he found that Mr. Clark had not followed his instructions to contact the U.S. Attorney. And Mr. Rosen even provided the U.S. Attorney's cell phone number for him. Instead, he had conducted some investigation by telephone on his own, speaking to witnesses, we don't know who, supposed witnesses in Georgia, including a bail bondsman, whose expertise in election contests is not clear. And that he, Mr. Clark, still had some doubts about whether there was a problem. So on January 2, which is a Saturday, there was another meeting between Mr. Clark and Mr. Rosen and Mr. Donahue. And at that meeting, Mr. Clark revealed that despite his promise that he would adhere to the rules about White House contacts, he had again been in contact with the president, and that the president had authorized him to replace Mr. Rosen to become the acting Attorney General of the United States. Mr. Clark said that he was thinking about that, but he would not do so if they would agree to send this proof of concept letter. And Mr. Donahue and Mr. Rosen adamantly refused to send the letter because it wasn't true. The following day was January 3, a Sunday. On that day, Mr. Clark again met with Mr. Rosen. Mr. Donahue was not present this time, although he was there at the party. And Mr. Clark told Mr. Rosen that he had decided to accept the president's offer and to replace Mr. Rosen as acting Attorney General of the United States, at which point he would send the proof of concept letter to Georgia. Mr. Rosen told Mr. Clark that I'm a presidential appointment. You don't have the power to fire me. Only the president can fire me. And so the president is going to have to be fired to fire me. And Mr. Rosen then arranged a meeting in the Oval Office with the president, which occurred that evening around 6:15, 6:30. There were 8 people present at this meeting. President and Mr. Clark, 3 lawyers from the Department of Justice, Mr. Rosen, Mr. Donahue, and the head of the Office of Legal Counsel, and 3 lawyers from the White House. The White House Counsel, Mr. Cipollone, his deputy, Mr. Philbin, and another lawyer. The president said at the meeting, look, you guys, referring to Rosen and Donahue, are not going to do anything to help me out here. And Mr. Clark made it clear that if he were appointed, he would send this letter. All of the other participants in the meeting, all 6 lawyers, adamantly opposed this. The letter was not true. Mr. Clark was not competent to run the investigation and to be Attorney General of the United States. If Mr. Clark were appointed acting Attorney General, the leadership of the Department of Justice en masse would resign. The White House Counsel would also resign, as would the other 2 lawyers that were present there. This meeting went on for 2.5, maybe 3 hours. Only Mr. Clark advocated the course of conduct set forth in his proof of concept letter. And at the end of the meeting, the president decided that he couldn't do it. He couldn't replace Mr. Rosen with Mr. Clark. Even then, even after the decision was made, Mr. Clark urged him to reconsider, but he would not do so. And so that ended the matter, at least so it seemed. The letter wasn't sent. The Georgia legislature did not convene in special session. An alternative set of electors was not sent to Congress. And so this threat to the stability of the proceedings that were to occur on January 6th was ended. It was headed off. But what Mr. Clark was attempting to do was essentially a coup at the Department of Justice. An attempt.
I've got to object. This is a pure argument and is far outside the scope of the charges that have been filed against Mr. Clark. and it's inflammatory or prejudicial action. He knows better than that.
Mr. McDougall, we'll consider what he has to say. I understand the perception that the term is inflammatory and maybe it's inappropriate, but I'll let him argue his point or present his point, and we'll consider whether the evidence supports it.
This was an attempt to use the authority of the Department of Justice to overturn the results of the election based on no factual support, based on a lie. There were no concerns that the department had, that there were allegations of fraud, that there was evidence of fraud that would affect the results of the election. And Mr. Clark didn't have any either. We expect through the course of this hearing that the respondent will offer a testimony of so-called experts about allegations that they thought needed to be investigated. You all can judge whether these experts are really experts. You can also judge whether there's any foundation for their testimony as to whether or not Mr. Clark knew about this information at the time he was advocating his course of conduct. But even if he did, the evidence that they will produce will not show that there were any legitimate concerns of election fraud that could have affected the results of this election. If Mr. Clark had written a truthful letter, what the letter would have said was that if I am appointed, perhaps I can look further and develop more evidence, and perhaps that evidence might have affected the results of the election. But that's not what he said. And that's not what he asked the Department of Justice to say. I don't know what Mr. Clark's, and it's not really relevant, motive was. But the methods that he used in this attempt violated the rules of professional conduct. He attempted to have the Department of Justice send a dishonest letter. And he attempted by the use of that letter to substantially interfere with the administration of justice. And it's for that conduct that is, and it's for attempting to engage in that conduct that violates the rules of professional responsibility.
Thank you, Mr. Fox. Mr. McDougall.
We filed a preliminary motion last evening raising some threshold issues, and we'd like to have a very brief argument about that. And with the lead of the committee, I'd like for Mr. Clark to be given permission to present that argument. He is a lawyer, is entitled to represent himself. How long do you think it was that? 5 minutes, depending on questions, as a preliminary matter.
Mr. McDougall, I saw your motion this morning. Okay. Disciplinary counsel hasn't had the chance to respond to your motion.
That's true.
It wasn't filed in accordance with Board Rule 7.22. And I don't think I want to get off on that foot. We'll consider your motion appropriate time. Let's begin with the oral. Okay.
Good morning.
Good morning, Mr. McDougall.
I'm Harry McDougall, and it is my honor to represent Jeffrey Clark along with Charles Brown and Mr. Destro. The evidence in this case is going to show you the following things. Number one, Mr. Clark at all times endeavored to do the right thing. He did not violate any rule of professional conduct, and certainly not the ones that are charged in the specifications in this case. Number two, Mr. Clark's letter proposed recommending to the Georgia legislature that they carry out additional investigations of the elections if they chose in their discretion to do so. And the evidence will show you that there was something worth investigating in Georgia. And I'll tell you about some of that in a minute. Number three, no one has ever been charged by the DC bar with attempted dishonesty in a draft letter that recommended a change in policy or position when that document was not approved and never even left the office. That is absolutely unheard of. There are no prior cases of that in DC. And as far as we can tell, there's never been a bar discipline case on a set of facts like that in the entire United States. The same is true of the second charge, which is attempted serious interference with the administration of justice. No such case has ever been brought on similar facts over a draft, deliberative process, confidential draft that never left the office. There is no identifiable court, there's no identifiable tribunal, there's no identifiable proceeding, there is no interference, there is no adverse effect, there is no nothing. This was an internal debate and an internal disagreement. The letter was never released by Mr. Clark or by the president. Once the president had made his decision, it was over. But somebody else did. One of the lawyers in that room leaked the issue, the matter, the discussion to the New York Times in breach of their professional obligations of confidentiality. Now, why does it matter that there's never been a case like this before? It matters for two fundamental reasons. The first is the due process clause of the Constitution, and it requires that before somebody is punished for breaking a rule, they have to have fair warning of what the rule prohibits. There's no fair warning here because nobody, other than Mr. Clark, has ever been charged on a similar set of facts. The second fundamental reason is that the extreme novelty, the fact that this is the first such case ever brought, means that the Office of Disciplinary Counsel will not be able to prove one of the essential elements of its case, which is jurisdiction. To have jurisdiction over Mr. Clark under the statute that the ODC is traveling, which is 28 USC or United States Code section 530B, the discipline in the case must be applied to the same extent and in the same manner as other attorneys in that state. Well, it cannot be applied to the same extent or in the same manner as other attorneys in the District of Columbia because nobody has ever been disciplined over a draft confidential document that never left the office. Second, the federal regulation that they're trying, which is 28 Code of Federal Regulations 77.2, expands on that requirement. It says the same, it's basically the same point essentially. And it says that lawyers, DOJ lawyers like Mr. Clark, shall only be subject to laws and rules of ethical conduct governing attorneys in the same manner as such rules apply to non-department attorneys. If Mr. Clark were being treated in the same manner as non-department attorneys, we would not be here because there's never been a case of discipline over a draft letter that was never sent. So the evidence is going to show that ODC cannot meet the threshold jurisdictional requirements of this case. The fourth thing the evidence is going to show you is that we just shouldn't be here. This case never should have been filed. The evidence will show that the theories that ODC has articulated just do not make any sense. The case lacks merit, and an inference is supported that it was filed for some reason other than the merits, which is a campaign to destroy conservative lawyers who were willing to raise issues about the election, even in privileged and confidential deliberations. I want to go through these topics in a little more depth. Mr. Clark did not violate any rule of professional conduct in discussing this letter with his two bosses at the Department of Justice, nor in preparing it. He did not violate any rule of professional conduct in discussing it with the president and the president's senior legal advisors in the Oval Office. He's charged with attempted dishonesty in the letter. He's not charged with having a bad idea. That's not against the rules. He's charged with attempted dishonesty. And when I explain to you exactly how it's alleged to be dishonest, I think you're going to be scratching your head the same way I've been scratching my head for the last 2 years. First of all, this letter was always subject to approval of Mr. Clark's superiors. It was drafted for the signature of Mr. Rosen and Mr. Donahue, and therefore on its face was subject to their approval. And it says at the top of every page that it's pre-decisional, meaning a decision has not been made, that it's protected by the deliberative process privilege, attorney-client privilege, and so on. The transmittal email asks them to approve it. Obviously, means that it's subject to their approval. Now, of course, they did not approve it. They thought it was not a good idea. And on January 3rd in the Oval Office, they convinced the president not to do it. Now, the letter proposed that DOJ take certain positions regarding the election in Georgia that were different than the positions that DOJ had at that time. Now, what is DOJ for purposes of that statement? It's the DOJ's leadership. They make the decisions about what DOJ's position is, and they can change their mind, or the leadership can be changed, and the new leadership can take a different position. Because the department can only act through its agents. DOJ is not some disembodied voice in the clouds. It's not a fourth branch of government. The position of the DOJ on these matters is what Mr. Rosen and Mr. Donahue thought, and before them, Mr. Barr, or their boss, the President of the United States, because he is the chief law enforcement officer. The charge laid against Mr. Clark is that the letter is attempted dishonesty. How exactly is it dishonest? According to the specification of charges, the dishonesty lies in the difference between the position proposed in the letter and DOJ's position at the time. I'm not making that up. The charges go through various iterations of that. In paragraph 15, the proof of concept letter stated that the Department of Justice had identified significant concerns that may have impacted the outcome of the election in multiple states, including the state of Georgia. The specification goes on. This statement was false. The department was aware of no allegations of election fraud in Georgia that would have affected the results of the presidential election. Now I want to use a metaphor with y'all. You know the game where you have 3 shells and there's a pea under one of the shells and you shuffle them around. You got to keep your eye on the pea. And look, you got to watch the pea right here. Okay. There's a difference between what the letter says and how the specifications allege that that is false. The part of the letter that's quoted is that DOJ has identified significant concerns that may have affected the outcome of the election in multiple states, including Georgia. The allegation that that's false is not quite the same. It's aware of that the allegation that it's false is the department was not aware of any allegations of election fraud that would have affected the results of the presidential election. So there's a couple of dimensions in which those are not lined up. One is significant concerns versus fraud. The second is may have impacted versus would have impacted. And the third dimension is in multiple states, including the state of Georgia, whereas the allegations appear to be referring to the national election. So the charges don't even sufficiently allege that the letter is false in that respect. So let's go to paragraph 16 and remember to keep your eye on the people. The proof of concept letter stated that the Department of Justice found troubling the current posture of a pending lawsuit in Fulton County and the litigation's sluggish pace. The statement was false. The department had no involvement in the Fulton County case and was not concerned by its lack of progress. Again, it's the difference between what's proposed in the letter and what Mr. Rosen and Mr. Donahue's opinions were. Proposing a change in position is not attempted dishonesty and never has been. Paragraph 18. The proof of concept letter stated that the Department of Justice had concluded that the governor should convene a special session with the Department of the Georgia legislature. The statement was false. The department had not made such a determination. Again, it's a proposal that the department change its position. That's not attempted dishonesty. And it goes on in the same vein. All of the allegations are couched in that the allegations of attempted dishonesty are couched on the same one. The letter proposes the department to say X. The department's position is not X. I want you to think through some of the implications if this were the rule that proposing a change in a position was attempted dishonesty. Is it attempted dishonesty to propose a new position? No, it isn't. Is it attempted dishonesty for a Supreme Court justice to write a dissenting opinion, a different position than the majority opinion? No, it is not. Is it attempted dishonesty for a member of Congress to vote for a piece of legislation that does not pass, merely because they took a different position than the majority? No, it is not. Every bill that's introduced in Congress begins the same way. Be it enacted in Congress assembled. When the bill's introduced, that is 100% not true. It hadn't passed. It's just introduced, but that does not make it attempted dishonesty. It's a proposed piece of legislation. So there is nothing dishonest and nothing in violation of the rules of professional conduct about proposing a change of position. And if Mr. Clark disagreed with Mr. Rosen and Mr. Donahue, the rules of professional conduct constantly authorize and encourage the lawyer to take their concerns to a higher authority. That's the ethical responsibility of someone who has a genuine difference of opinion. Now, once the president did decide, that was the end of it, the absolute end of it. The fact that the president decided against the letter does not make Mr. Clark unethical or prove that he violated any of the rules of the DC Bar. And the evidence will show you, and just a moment's thought will show you, that if the letter had been approved and it had been sent, then it would be the position of the Justice Department. It would be an expression of where the department stood, according to its policymakers and decision makers. So in that event, it would be a true statement of the department's position. And so if we're speaking according to strict logic, it would be more appropriate to call this letter an attempted honest statement rather than an attempted dishonest statement. That's not a violation of the rules. So the evidence is going to show you that the charge of attempted dishonesty is groundless and just does not make a lick of sense. Another reason Mr. Clark did not do anything wrong is that the statements in the draft letter that are alleged to be false are obviously on their face matters of opinion and judgment. There's an opinion or judgment about what evidence exists or does not exist regarding election irregularities. It's an opinion or judgment about the significance of that evidence. So does it exist? What is its significance? And there's an opinion or judgment about what, if anything, ought to be done about it. And all of these opinions or judgments are being formed and debated in a very contentious and hotly disputed environment. So why does it matter that these are matters of opinion? What's the significance of that for this case? Opinions are not facts. Facts can be proven false, but opinions cannot. And you see that all over the law, especially in the law of defamation. You cannot punish a person for attempted dishonesty for their opinion, because for the time being, we do not yet live in the novel 1984. Mr. Clark did nothing wrong in having a different opinion than Mr. Rosen and Mr. Donahue, especially if it was a sincerely held opinion, as the evidence will show. Mr. Clark, as I mentioned, has an ethical, professional responsibility to present his independent judgment, even if his two bosses do not agree with it. You will hear from former Attorney General Edwin Meeks and from a professor at the Yale Law School that under the opinions clause of the United States Constitution, the president has the right to seek Mr. Clark's opinion if he chooses to. And if he does, then Mr. Clark is obligated to give it. And when he acts under that higher constitutional authority, it is not for the DC bar to get in the middle of that and punish him. In the Oval Office meeting on January 3rd, the 6 lawyers argued against Mr. Clark. Everything about the letter, everything about that meeting, all of the communications about the letter inside the OJA and at the Oval Office occurred under the protection of privileges, a whole list of privileges, including executive privilege, the liberty process privilege, law enforcement privilege, and attorney-client privilege. Why does that matter? Those privileges are all designed to give the participants the assurance that they can speak freely without having their comments and opinions on the front of the New York Times within a week's time. Because if they didn't have that assurance and they were worried about the newspapers lighting them up for what they said when they gave their candid opinion, they would shade their opinions. And the quality of the decision making at the highest levels of government would suffer. The president needs candid advice from his opinion, from his advisors. And the privileges are one of the main way that he's able to get that. Mr. Clark should not be here for giving his candid opinion and independent judgment under the protection of those privileges any more than any of the other lawyers in the room should be in here for giving their candid opinions. And they should, none of them should. But because one of the lawyers in that meeting leaked it or caused it to be leaked, here we are. It was in the New York Times on January 22nd, 2021. The exact nightmare scenario contemplated in Nixon versus US. It's for the President of the United States to decide whose advice to follow, not the DC Bar Association. And indeed, with the utmost respect, not the members of this committee, but the Board of Professional Responsibility. The evidence will show you there will be a terrible chilling effect if the President's advisors were subjected to bar discipline for offering candid opinions in confidential deliberations and for proposing changes in policy on the grounds that they were dishonest. It will be a terrible blow to the profession and to the country if lawyers were disbarred for suggesting a change in policy in a document that never even leaves the office. Anyone could be strung up if that were the law. And you really would be in 1984, where people were punished for thought crimes. The evidence is also going to show you that there was something worth investigating in the Georgia election in 2020. You will hear from cybersecurity experts who studied the Dominion system and the available literature on that topic, and we will tell you that the system was shockingly insecure and vulnerable. Virtually every expert who's ever looked at it has come to the same conclusion. Well before the 2020 election, alarm bells were ringing out there. A federal judge in Atlanta, Amy Totenberg, in October of 2020, ruled that the system was insecure and did not comply with Georgia law. All of that was in the press and in the air in the fall of 2020. The evidence will also show you there was a huge problem with the certification of the signatures on absentee ballots in Philbin County. You will hear from a former member of the Philbin County Election Board named Mark Wingate. Mr. Wingate voted against certification twice. There was a count and a recount. He voted against certification twice. He had a number of reasons, which he will tell you about. But one of the reasons was that he was told by the director of the elections department that Philbin County did not do any signature verification at all on absentee ballots. None. They had bought a computer system that was supposed to help them do that, but it never worked. Now, we're going to speak over here.
Well, I'm a little concerned whether people can hear you if you don't have a mic on you.
Yeah. Okay. This board showed you relevant provisions of the absentee ballot signature verification statute in Georgia for the 2020 election. Code section 21-2-386. And subsection B requires the clerk to compare the signature on the ballot envelope with the signature on file. And, it's statutory language, so it's a little bit clunky, but that's the gist of it. Subsection C says if the signatures don't match, the ballot must be rejected. Now, under the electors clause of the Constitution, the only people that can change that is the Georgia legislature. Oh, you can say that. Was it the floor issue or was it more than one ballot? All right, so my morning colleague, Mr. Burnham, is holding up a page published by the Election Assistance Commission, a federal agency that exists to help states and local governments put on elections. They collected statistics about the 2020 election. And what you can see there on that list is Fulton County. It's a little bit faint. I can't help that. That's the way it came on the page. But Fulton County is on there, and it shows that Fulton County accepted 146,029 absentee ballots in the 2020 election. And of course, the EAC is an independent federal commission. It's not the Trump campaign. It's not a bunch of MAGA people. It's not a bunch of election deniers. It's federal. It's a federal office. Let's see the second one, please. The total number of absentee ballots that were rejected in Fulton County for all reasons put together. Oh, yeah. The total number, the leftmost column for Fulton County, the total rejected for any and all reasons is 69. And then there's a series of columns that breaks out the percentage rejected for each of several reasons. One of the columns is rejection for signature mismatch. 8.7% of 69 were rejected for signature mismatch. And if you do the math, 8.7% of 69 is 6. 6 ballots were rejected in Fulton County out of 146,000 for signature mismatch. 6 is the number between 5 and 7. And so what it shows you is that effectively, Fulton County did not do any signature verification at all, just like Mark Wingate says. And that is a massive violation of the absentee ballot statute that I showed you. Those ballots were required to be examined before they could be counted. And if there's a bad signature, it has to be rejected. Okay, you can set it. And not having checked them, the legal logic, the legal reasoning is inescapable. They should not have been counted. And that means Fulton County could not be certified because the certification says this is a true number. Nobody knows what the true number is because they didn't do what they were supposed to do. Now, the evidence is going to show you that the president himself was asking about absentee ballot signature verification in Fulton County. And we see he was right to do so. He asked Mr. Rosen and Mr. Donahue about it. They blew him off. The president, through Mr. Meadows, asked Mr. Clark to have Mr. Clark look into signature verification. He asked him about it in a phone call, which Donahue made notes of. But this is an email from January 2nd. And you can see in the middle of the page that on January 2nd, Mr. Meadows, Chief of Staff to the President, wrote to Mr. Meadows and said, Mr. Rosen said, there have been allegations of signature match anomalies in Fulton County, Georgia. Can you get Jeff Clark to engage on this issue immediately to determine if there's any truth to this allegation? And I hardly need to remind you, it wasn't get Jeff Clark to lie about this, it's get Jeff Clark to find out if it's true. And how did Mr. Rosen and Mr. Donahue react to that request? Rosen forwards it to Donahue and he says, can you believe this? I am not going to respond to the message below. And Mr. Donahue said, at least it's better than the last one, but that doesn't say much. And that's how those two gentlemen responded to a concern articulated to them by the President of the United States that was in fact 100% correct and 100% valid. They reacted to it by mocking it and blocking it. You will hear evidence that DOJ, other than Mr. Clark, did not look into signature verification in Fulton County at all. And Mr. Clark stands here accused by the bar of attempted dishonesty for suggesting that there were valid issues to look into in the Georgia record. So, sir, now why would it make any difference? Why would it make any legal difference? That these procedures were not followed, the absentee ballot procedures were not followed. And Mr. Berman was holding up a board that has excerpts from the Georgia election contest statute. 21-2-522, subsection 1. Misconduct, fraud, or irregularity in any primary or election official or officials sufficient to put the outcome in doubt. Okay. Not following the absentee ballot statute and accepting 146,000 ballots in violation of the statute is misconduct or irregularity. And it's sufficient to put the outcome in doubt because the margin in Georgia was less than 12,000 votes. Subsection 3. When illegal votes have been received, it's illegal to count a vote where the signature has not been verified in 2020 in Georgia. 4. For any error in counting or declaring the results. Now, I don't have 4 excerpted, so I won't ask you to take my word for it. We're not there yet. But there's an irregularity under section 1 that will be sufficient for election contest. Now, it doesn't have to be fraud. It can be an irregularity. So the evidence is going to show there's a reasonable basis, a legitimate basis for raising questions about the election in Georgia, and especially in Fulton County. Mr. Clark, the letter was not false in suggesting that there was something worth investigating. And remember, the alleged dishonesty is proposing that DOJ take a position that was different than the one held by Mr. Rosen and Mr. Donahue. Their position was there's nothing to see here, moving on. But there was something to see. The evidence is going to show you that the whole case is based on the idea that the draft letter is dishonest because DOJ personnel, other than Mr. Clark, had already determined there was nothing to this point. But the evidence is going to show you they didn't look at it at all. They didn't have a position because they didn't look at it. So how can Mr. Clark contradict a position that didn't exist? You'll hear evidence of other irregularities in the Georgia election and further validate the premise of Mr. Clark's election. Mr. Clark did not know that. Now, I've already discussed the one thing before I leave the absentee ballots. Fulton County processed absentee ballots in a different way than other counties in Georgia. In the Bush v. Gore case in the 2000 election, stands for the proposition that if one county counts them according to one standard and another county counts them according to a different standard, it's a violation of the equal protection clause. But as the voters' votes should be treated the same. They should be subjected to the same kind of scrutiny. And if you throw the bar door open and let every piece of paper be counted in one county and other counties applying strict scrutiny to the signatures, you have an equal protection problem, different standards. Yeah, the difference of that would be in the first case now. We'll go back to that for a second. We have challenged the Office of Disciplinary Counsel for almost 2 years now to show up the case in DC that was satisfied their threshold requirement that non-department laws have ever been subjected to discipline for attempted dishonesty and sought disbarment over a confidential draft of the document that left the office. Show us a case for a non-federal law, disbarred for opinion substantial interference with the administration of justice under those circumstances. Confidential drafts that never left the office. And what response did we got? Crickets. Nothing. We do not have to prove the non-existence of jurisdiction. They have to prove the existence of jurisdiction by clear and convincing evidence, and they cannot meet the threshold requirement. Because this was a confidential discussion, nobody other than the participants in this discussion in the whole world knew anything about it until after President Biden took office on January 20th. The story was published January the 22nd. The bar proposes that this bar was deployed for what amounts to a thought hunt. What would be next? Arguments for a brief that were drafted but not made, but deleted from the brief before it was filed. Emails or text messages that were prepared but never sent. Arguments described orally to a colleague over lunch or in a meeting, but were never written down or made in court. I think you see the problem. Where do you draw the line? Where you draw the line is, if it never leaves the office, that's a perfectly workable line. Enforces the bar rules, protects the public, serves every legitimate purpose of bar discipline. This is way over the line. Unsent drafts should never be the subject of bar discipline. The DC Court of Appeals, when it comes to substantial interference with the administration of justice, they have set out what the requirements are for that, what the bar has to do. They have to prove the conduct is improper, that it bears directly, not hypothetically, on the judicial process with respect to an identifiable case or tribunal, and that it harms the judicial process in more than a de minimis way, meaning insignificant way. Well, the evidence will show you, as I've already said to you, that there's nothing improper about proposing the draft, sending it to his bosses, and discussing it with his bosses. And let the big boss decide, which is what you're supposed to do. It's not against the bar rules to have an idea that the disciplinary council doesn't like, or any idea that even perhaps one he doesn't like. What do you know? Bar rules don't address them. They don't address the content of your ideas. There'll be no evidence that the draft letter bore directly on the judicial process with respect to an identifiable case or tribunal. It is a purely hypothetical, speculative conjecture by bar counsel. There's no identifiable case or tribunal because there's no case in the tribunal. There's just no there there. And no harm in the judicial process from a document that was never left the office. So we should not be here on that charge. The disciplinary council spent a good bit of its open statements to hang on to Mr. Clark. A lot of things that are outside the contours of the two charges that have been laid against Mr. Clark. He tried to link all of this with much more serious matters. Mr. Clark's not before the one charge. He's not charged with political unrest. He's not charged with any of that. Charged that they chose him. And sat down and wrote about it. On one thing I've discussed with you already, and they don't withstand scrutiny. And so Mr. Fox goes into all that other prejudicial stuff. Watch the people. He's talking about something other than what he has to prove. Now, I told you that the article charges in the case don't make sense. We pressed that point very vigorously throughout the history of this case. As a result of that, the bar began to change its story, change its theory in this case. And evidence will show that as a result of the pressure we were putting on the illogical nature of their arguments, that back on September the 1st of 2022, they said this in a brief that was filed in this case. Had respondent merely suggested sending the so-called proof of concept letter to various Georgia officials, this case would not have been brought. And he pretty well said that in his opening statement. That was in their omnibus response to our September 1, 22 filings on page 2. Now, if that's disciplinary counsel's position, there's nothing wrong with suggesting sending a proof of concept letter. I have to ask, why are we here? There's nothing wrong with it. Why are we here? The whole case is about what's wrong with it. He agrees, apparently, that making a proposal does not violate the bar rules. And having made that concession, the case should have ended right there. But they came out with a new theory, which was that Mr. Clark excessively persisted in making the suggestion until the president decided against it. Excessive persistence is the new theory, and attempted coercion. So where we are is that first they said it was attempted dishonesty to suggest sending the letter. And now they say there's nothing wrong with suggesting to send the letter. But which is it? That's what I call crawfish number 1. There's no problem against excessive persistence. There's not a word about that in the specification charges. It was just made up out of thin air because his arguments fall apart. Mr. Clark cannot be punished for violating a rule that didn't exist, that does not exist, and was just made up in the course of writing. Why does that matter? Because Mr. Clark is entitled under due process clause of the United States Constitution a fair notice of where the line is beyond which he can be punished. What bar rule would it violate if the president made Mr. Clark the acting attorney general? The president has illimitable power, unlimited power to remove his appointees and appoint new ones. The bar rules cannot restrain the authority of the president of the United States under Article 2 of the Constitution to appoint officers like the attorney general. So crawfish number 1 makes even less sense than the original charges. And we pointed that out. And under the pressure of that argument, the bar changed their story again. And they went over to crawfish number 2. Over in federal district court, when we were litigating the question of removal, the bar argued this. Respondent consistently mischaracterizes these charges. And when disciplinary counsel responds to those mischaracterizations, accuses it of having changed the theory. And this is the key part. Disciplinary counsel has never accused respondent of lying to his superiors. They filed that in federal court. Signed their names to it. So you got that. In a case in which Mr. Clark is accused of attempted dishonesty in this draft letter that he sent to his superiors, disciplinary counsel has said in writing that it has never accused Mr. Clark of lying to his superiors. So twice now, disciplinary counsel has exonerated Mr. Clark of the first charge of attempted dishonesty. So I'm tempted to ask, can we go home now? Why are we here? We're not here because of any actual or attempted dishonesty, even according to disciplinary counsel. So why are they trying to disbar Mr. Clark? It just does not make any sense. Now, I am sure, I think, that some of you must be wondering why we have fought so hard in this case. I hope by now you have some appreciation for why we have fought. These charges are unjust. It is an honor to fight unjust charges. It's the highest calling of the law. When this case is all said and done, I hope that you will agree that we were right to fight an unjust case. Mr. Clark did nothing wrong. We should not be.
Thank you, Mr. McDougall. All right, why don't we do this? Why don't we take a 15-minute break and then call our first witness? Do people have preferences and time for a lunch break? I was thinking if we started a witness at 11:15, maybe we try to go to 12:30. Does that make sense with people?
Yeah, the only my only, quibble is, if we're close to finishing direct examination, it might make sense, but yeah.
Yeah, no, I'll be flexible in that way. I don't want to, break halfway through someone's answer. Lunchtime, sorry. Obviously we'll adjust to how the evidence comes in, but does that make sense as a kind of guide for at least today? It may be that tomorrow things, shake out in a slightly different time, but. Okay, we're in recess till 11:15.
How long? Thank you, Mr. Chairman.
Okay, I guess we're back online. All right, Mr. Fox, call your first witness, please.
Richard Donahue.
Letting in Mr. Donahue's counsel.
We're just discussing whether it goes the rule. We have no objection to it, and all of my witnesses has been told not to.
And if I think it might be helpful if the chair instructed any witnesses.
Okay, I gotta run for the hearing, but I'm happy to catch up later this week or next week. after
Mr.
something.
Andres, you're not on mute.
Oh, sorry. Sorry about that.
All right, the parties are invoking the rule on exclusion of exclusion of witnesses. And so accordingly, the witnesses are not supposed to, who have not yet testified, are not supposed to be listening to the testimony. That's true not only here in the courtroom, but it's also true on YouTube. And I ask counsel to instruct all of their witnesses not to observe the proceedings or listen to it or talk to witnesses in light of that. Does that cover the request, Mr. Fox? But I want to make sure.
We have an expert witness who indicated.
Mr. McDougal, can you speak into the microphone so we can hear you?
Right, you need to speak into the microphone, Mr. McDougal. People can't hear you.
We have an expert witness who indicated the desire to watch testimony. And my understanding, we will see permitted to do that. I want to make sure.
Yes, expert witnesses are exempted from that, and obviously parties are exempted from it too. All right. Mr. Donahue, do you wish to swear or affirm in your?
I will swear, sir.
Okay. Could you please raise your right hand? Do you solemnly swear that the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you please state your full name for the record?
My name is Richard Peter Donahue, Donoghue.
Thank you very much, Mr. Donahue. Please proceed, Mr. Fox.
Mr. Donahue, would you tell us a little bit at the outset about your career? Start, if you will, with your enlistment in the military.
I'm sorry, I enlisted in the United States Army Reserves in January of 1985. When I was 17, I spent approximately 20 years in the military, from 85 to 2006, a little more than 20 years in various capacities, mostly in the reserves. Spent 7 years in active duty as a Judge Advocate General Corps officer. Got commissioned in 1989 as a lieutenant. I served in various capacities on active duty, mostly at Fort Bragg, among other units, the 82nd Airborne Division.
And I assume sometime during that period you became a lawyer, correct?
I did. I went to law school and graduated in 1992 and was admitted to the New York Bar in 1992 before moving on to active duty in January of 93.
And would you tell us something about your experience as a prosecutor?
I was a prosecutor on multiple tours in the JAG Corps, so defense counsel and administrative law attorney and a number of other things. But I left the JAG Corps active duty component in January of 2000 and went to the Eastern District of New York U.S. Attorney's Office, where I was a prosecutor for just under 12 years before leaving that office the first time.
And when you left the office the first time, what was your position?
I left as the chief of the criminal division for the U.S. Attorney's Office.
And did there come a time when you returned to the U.S. Attorney's Office in the Eastern District of New York?
Yes, I left in November of 11. I worked at a Fortune 500 software company for about 6 years. And I returned to the Eastern District of New York U.S. Attorney's Office in January of 2018 as the U.S. Attorney.
How long did you serve as the U.S. Attorney?
Until July of 2020, when I went to Washington to take up a position as the Principal Associate Deputy Attorney General, otherwise known as the PADAG, P-A-D-A-G.
Tell us a little bit about the nature of your work as the Principal Associate Deputy Attorney General.
So that position is in the Office of the Deputy Attorney General, as the title implies. There are approximately 10 or 12 associate deputy attorney generals, ADAGs. The PADAG is the principal among them and reports directly to the deputy attorney general and assists the deputy attorney general and the attorney general in essentially running the department on a day-to-day basis.
When you assumed this position, who was your boss?
I report directly to the deputy attorney general, as I had as the U.S. attorney as well.
And that individual was who?
That was Mr. Jeffrey Rosen.
I want to jump forward to the 2020 election. At some point after the election, did you send around a memorandum to the assistant attorney generals in the department concerning White House contacts?
Yes, that was in early November, sometime after the November 3rd election. I think it was around the 9th or so that I sent out a reminder about the White House contacts policy, which had been a longstanding policy in the department.
Why did you send that memorandum out shortly after the election?
I sent it out pursuant to a conversation I had with Attorney General Barr's chief of staff, Will Levy, Levi. Mr. Levy reached out to me, said that he had sent it out, I think, to the people he supervised, which would have been the lawyers on the AG's direct staff. I don't remember the specifics, but he thought it would be a good idea to send it, given a lot of the churn that was going on following the election, and it seemed like a prudent step to me, so I sent it out.
I know can you just summarize what the White House contacts policy was at that time?
Essentially, it limits contact between the White House and the department, and the White House itself has a corresponding memo on their side, which does the same thing. And the purpose is to limit, particularly with regard to criminal matters, contact between the department and the White House to the highest levels of the department. So essentially, the Attorney General, the Deputy Attorney General can have contact with people at the White House, particularly the White House Counsel and the Deputy White House Counsel, to discuss criminal matters and things of that sort. And the purpose really is to put a little bit of a buffer between the department and the White House.
To whom did you send this memorandum?
I sent it to all of the assistant attorneys general, the AAGs. The AAGs had each of the components within the department. So probably about 7 individuals or so.
And was one of those individuals Mr. Clark?
Yes.
What was Mr. Clark's position at the time?
At that time, Mr. Clark was the Senate confirmed AAG in charge of the Environmental and Natural Resources Division, the ENRD. But by November, he was also the acting attorney general for the Civil Division. So he had moved over, was no longer working in ENRD, and was at the Civil Division, which is also headed by an AAG.
Are you familiar with a memorandum that Attorney General Barr sent around after the election concerning election fraud investigations?
Yes.
Could you tell us what that memorandum said, in essence?
The November 9th memo essentially speaks for itself, but essentially said to the U.S. attorneys that they had authority, which they always had, despite the memo, to investigate instances of election fraud allegations as they deemed appropriate. It gave some guidelines as to what would be appropriate in terms of whether the allegation is credible, whether it's of the nature that might actually impact the outcome of an election in an individual state. And the AG's memo modified guidance that had been previously provided by the Election Crimes Branch in memos that had gone back for several years. Essentially, the Election Crimes Branch had a very passive and delayed approach to elections crime enforcement. And given everything that was going on after the 2020 election, AG Barr felt that a passive and delayed approach would not be appropriate because the American people couldn't trust the outcome of the election unless the department itself looked at allegations that were significant enough to warrant their attention.
And you say it had a passive approach. What in essence was the passive approach that had been taken in the past?
The election crimes branch view of election criminal law enforcement was that everything should wait till the election is over. And then once the election is over and certified, then you could go in and do overt investigations. And their goal was really to deter misconduct in future elections. The problem, of course, was that if you, in the course of doing these subsequent elections, realized that there was fraud or misconduct on a scale that changed the outcome of the election, there was no way to cure the election that had just taken place. So AG Barr was very concerned about that approach, given that it was a presidential election. There was no way to redo a presidential election. There actually have been instances where congressional elections had been redone because of fraud. You couldn't do that with a presidential election. So AG Barr wanted to make sure that the U.S. attorneys understood that they had the authority to investigate.
Was this change controversial in any way?
Yes.
And how so?
The people in the election crimes branch did not want to support that approach. They engaged in various types of objections to the policy. Some sent memos to the Attorney General himself, which was fine. Some leaked internal DOJ discussions to the media, which was not fine. The election crimes branch chief purported to resign. He resigned from his position as the branch chief, but remained in the department. And there was other sort of turmoil that resulted from this disconnect between the election crimes branch approach and what the AG's memo said.
You've mentioned the election crimes branch several times. Let's see if we can locate that within the organizational structure of the Department of Justice.
Sure. So there's a criminal division, just as there's a civil division. Criminal division is headed by one of the AAGs. Within the criminal division, there is a public integrity section that has a section chief. And then within the public integrity section, there is a branch called the election crimes branch.
Take a look, if we can, at Disciplinary Counsel Exhibit number 5. It's in the notebook before you. I think it'll also be up on your screen if you're easier of that.
Yes, I see it.
And like all these emails, you start from the back. So if you look at the last email, it's from Corey Admonson. Who is Corey Admonson?
Corey was the chief of the public integrity section at that point in time.
And just if you will summarize for us what was going on here in this email.
So the email chain runs from PIN. The public integrity section is commonly referred to as PIN, PIN. It goes through the FBI and eventually works its way up to me. But essentially, you're seeing the tension between PIN, which in this case is really speaking for the election crimes branch, and their desire to delay any investigations until after the presidential election is certified. And field units in the FBI, the U.S. Attorney's Office, and elsewhere that want to conduct at least limited investigations to know what's going on. So you can see it gets routed through Dave Bowditch, BOWDICH. Dave was the deputy director of the FBI, and eventually up to me. And I tell them to go ahead and conduct the limited investigation that they want to conduct.
And the investigation, that is a specific investigation that was being discussed here, is something about the State Farm Arena in Georgia. Can you tell us what that was?
Yes, there were allegations that there was misconduct in the State Farm Arena ballot collection facility. They were counting ballots in the State Farm Arena in Fulton County in Georgia. There were various allegations being made, some in civil litigation, some just on media interviews, some on the internet and other places, alleging different types of misconduct. And the FBI pursuant to the AG's November 11th memo to do some limited interviews of witnesses so that we could determine for ourselves whether there was something to be concerned about there. And if you go through the email chain, you'll see that the election crime branch said that they would not concur in taking such a step. This was a little bit misleading because the election crimes branch had no authority to tell the U.S. Attorney's Office or the FBI what to do. But when they would say that they would not concur with a step, that had a tendency to grind investigations to a halt because people in the field had been conditioned to believe that they could not proceed unless ECB concurred. And that's why it got elevated to me. And I told the FBI should go ahead and do the investigation they thought appropriate.
And there's a reference in your email on the first page in the middle of the first paragraph to the Georgia SOS. What is that?
Secretary of State.
And what, if any, involvement did the Secretary of State have in these investigations in Georgia?
They had already looked at some of the State Farm arena allegations, and they concluded that there was nothing nefarious there. And as I said, it may well be that they are correct. If so, and we investigate, presumably we'll reach the same conclusions. But either way, the public should have confidence in the election results in Georgia, and we should do our job.
And was that investigation in fact conducted?
It was, yes.
And did you, was there anything there that would have affected the outcome of the election?
No, FBI's conclusion and the conclusion of the U.S. Attorney's Office in Atlanta, which is the U.S. Attorney's Office for the Northern District of Georgia, was that there was nothing nefarious at State Farm. And based on that, there was no reason to question the conduct there or the outcome of the election in Georgia.
Okay. Thank you, Emily. You mentioned, you've already told us about the public integrity section and the branch of that section that investigates these allegations. What other portions of the Department of Justice would investigate these allegations of election fraud?
Primarily to U.S. Attorney's offices. We have 94 U.S. Attorney's offices across the country. There's a U.S. attorney for each of them. Within each of those offices, there's at least one federal prosecutor designated as a district election officer, a DEO. They have responsibility for investigations relating to election allegations. So you've got the U.S. Attorney's offices, you've got the public integrity section, you've got other units within the criminal division. You have the Civil Rights Division, which also had an AAG and was responsible for civil rights enforcement in relation to election matters. And then, of course, you had the FBI, which had its public corruption branch that also had independent authority to conduct investigations.
At the time of the 2020 presidential election, what, if any, efforts did the department make to publicize the availability of these resources to investigate allegations of election fraud?
Prior to the election, every U.S. Attorney's Office issues a press release that identifies their DEO by name. They also give sort of hotline numbers and I think websites and things where you can report allegations or concerns about election matters, criminal or civil, because these could cross the different practice areas. But there's an effort made to publicize the fact that the department is available to receive allegations, complaints, or issues.
With respect to your personal responsibilities, what responsibilities did you have with respect to the 2020 election investigations?
I served sort of as a clearinghouse for much of the information for the Deputy Attorney General and the Attorney General. Because I'd been a U.S. attorney, I knew just about all the U.S. attorneys in the country. I was very close to and friendly with many of them, so we worked well together. It was quite natural for them to let me know what's going on in their offices. We also had various reporting systems, including the urgent report system, where U.S. attorneys would send up daily reports about significant matters in their jurisdictions. Those all went to the DAG's office, so I saw all of those. I also sat above the criminal division, and thus the public integrity section in the elections crime branch. So a lot of the reporting that went up ended up on my desk from these various DOJ components. And of course, also the FBI within DOJ. I was working very close with the deputy director, as you can see from the email. So I got a lot of information directly from the FBI as well.
And that was Mr. Bowditch, whom you referred a moment ago.
Correct, Dave Bowditch, right?
It's a use the term DAG in that response. You meant, I take that means Deputy Attorney General.
Yes, I'm sorry, Deputy
That's
Attorney General, right?
Just with respect to Georgia, do you recall whether there were any allegations concerning document shredding in Georgia?
Yes.
What were those allegations, and how, if in any way, were they investigated?
Those were a little separate from State Farm. I can't recall if they happened in Fulton County or a neighboring county, but there were allegations that ballots were being shredded. We looked at that as well. And in fact, ballots were being shredded. My understanding is under Georgia law, they are required to keep ballots for 22 months. And that at the end of every election cycle, they shred because they're making room for the new ballots. So you have an election, they're storing new ballots. And as a result, once the 22 months time period has run on the earlier ballots, they shred those ballots.
So those would have been ballots from which election that were shredded?
I would, again, I don't know how much they stored and how far back they go. I would assume that would have been the 2016 election. Perhaps it was 2018. Not sure.
Was there an allegation concerning the error rate in, and I continue to mispronounce the name of this county in Michigan, Antrim, I think it is county. Antrim.
The county is Antrim, Antrim, Antrim County, Michigan.
And what were those allegations?
On, I believe it was December 13th, there was a report issued by an organization called the Allied Security Operations Group, ASOG, ASOG. And ASOG had done a review of some voting machines in Antrim County, Michigan, pursuant to some civil litigation that the department was not involved in. Civil litigation brought by a private party. Pursuant to that, the state court judge allowed ASOG to look at the Dominion voting machines and some of the other hardware that was used in Antrim County. And based on that, ASOG issued a report that alleged, amongst many other things, that there was a 68% error rate in Antrim County based on how the machines malfunctioned. We later found out that's not the case, but that was the initial allegation.
And after that was investigated, did you actually calculate what the actual error rate was?
It was about 1 in 15,000, which I think is 0.0063.
Okay.
So well within the tolerance rate for machines of that type.
And was there also an allegation concerning a Pennsylvania truck driver? Do you recall that allegation?
I do. There were a number of Pennsylvania allegations. That was one of them.
And what was that about?
The allegation was that a truck driver had driven an entire tractor trailer full of ballots from Long Island, New York to Pennsylvania, and that these were somehow fraudulent ballots that were then fed into the Pennsylvania voting system. And since Pennsylvania was only decided by about 80,000 votes, a tractor trailer would certainly be capable of carrying more than that. And therefore, we looked at that to determine whether or not that happened.
And what was the result?
The result was that did not happen. The truck in question was a parcel truck. It carried mostly packages, not ballots. We interviewed people at the beginning who loaded the truck, the people who unloaded the truck. We looked at the manifest, et cetera. It's possible that there were a small number of ballots in that truck because miscellaneous mail parcels can be added on to the end of a parcel truck. So it's possible that there was, a bin with some loose mail in it that may have contained ballots, but the truck itself was full of parcels.
Who at the Department of Justice was more knowledgeable about these investigations than yourself?
I would say that the U.S. attorneys and the FBI supervisors who conducted the investigation certainly knew the individual cases better. But in terms of the overall view of what the department had seen and learned, was pretty much on my desk.
What was your practice with respect to informing Deputy Attorney General Rosen and Attorney General Barr about the status of these investigations?
I gave them nearly real-time
Counsel
reporting.
with Alliance Defending
The
Freedom.
DAG and I
This
worked very
morning, we're going to
closely
hear from
together,
Aaron
so anything I
Hawley,
knew,
who just
he
argued
would have
on behalf
known
of
in
Alliance
very
Democratic
short
Medicine
order,
before the
like
court
within
this
minutes,
morning.
usually.
We will then hear
The
from
Attorney
Dr.
General,
Christina
we met every
Francis,
morning in his
one of the
office
clients in this
at
case.
9 a.m.
And then we will hear from the
I met
Kansas Attorney General,
with the Attorney
Chris
General throughout the
Kobach,
course of the day. It
after
was
which
not
we
unusual
will
to see
take
him several
time
times
for
a
a few
day.
questions.
And so
Aaron?
anytime I had something new, I would just make sure that he knew
Thank you
about,
so
hey, we
much.
heard about the
We
results in
should all
Antrim.
agree that women
This is what
deserve
actually
the
happened.
ongoing
Things like that.
in-person care of a doctor when
And,
taking high-risk drugs. But in 2016 and
How many
2021,
investigations
the
did you
FDA
find
recognized
of
nearly
matters
every
that
safeguard
might have had a
that had
significant
originally
effect
been
on the outcome of the
necessary for the use of
investigation?
chemical abortion
None.
drugs, including in-person office
When you
visits
said the outcome of the
to check for
investigation,
atomic
assuming the outcome of the
pregnancies,
election.
severe bleeding,
Election, I'm
and
sorry,
Yes,
life-threatening
there were
infections.
instances of
Without
fraud and
question,
instances of
the FDA's
misconduct, but
actions
none on
have
the
made
scale
taking chemical
that would have
abortion
affected the
drugs
outcome in any
less
individual
safe.
state
Today, I
or the
argue before
election
the
of the
United
whole.
States Supreme Court on
And
behalf
what
of
was
doctors
Jeffrey
and
Clark's
medical
involvement in
associations
these
who have witnessed
investigations?
these harms
None.
firsthand. The FDA violated federal law in its duty to keep women safe.
Did there come a
It's
time when
appalling
Attorney
that
General
the
Barr
FDA
made an
based its
announcement about
2021 decision
what the
to
investigations
remove
were
that
turning up?
in-person visit on studies
Yes,
it
on
acknowledged
December
were, quote,
1st,
not
I believe,
adequate.
he
Women are now left to receive these
spoke
drugs in the
to, I
mail
believe
or
it
in
was
their dorm
Associated
room
Press
without ever
reporter,
having been checked by a doctor
and made
for
a
life-threatening
comment
conditions.
that the
That's
department
reckless.
had done
Yet the
investigations
FDA
and
attempts to
not
argue that
found
these drugs are safe,
any fraud
even as
on the
safe as
scale that would
Advil.
change the outcome
That
of
is
the election.
simply false. The FDA's own
And was that
label
consistent
says
with
that
your view?
between 1 and 25% of women end up in the emergency room after taking mifepristone. That's
When, if you know,
not
did
adequate.
Attorney General
The
Barr
FDA has shown
resign
a callous
from
disregard
his
for what
position?
women and girls
He
experience
submitted
when
his
taking
letter to the
abortion drugs
president
all
on
alone.
December 14th.
Every
It was
American should
effective
be
midnight, the 24th of December. So he essentially left the department. He physically left mid-afternoon on December 23rd.
On the day that he submitted his resignation, the 14th, did you have a conversation with him after he informed the president that he was resigning?
Yes,
And tell us about that conversation.
he,
Object any part of this hearsay. Mr. Burke?
We're not obliged to follow hearsay in this, the hearsay rule in this proceeding, so I'll allow it.
All right, thanks.
the Attorney General returned from the White House, I would say late afternoon. His secretary called me, asked me to come upstairs. I went up to speak to him, asked him if he was still the Attorney General. He said he was. We had a very brief conversation about the meeting he just had with the president. He said the meeting was generally good and that he'd submitted his resignation. He would be leaving. And he said that now the president needs to decide who the Attorney General is going to be, which surprised me a little bit because I think we all assumed that it was going to be Jeff Rosen because that's the way the chain of succession within the department works. And so I said, well, it's going to be the dad, right? And he said, maybe not. He's thinking about it. Your name came up. You should be prepared to get a call and to be called over the White House, I would think tomorrow morning, to discuss whether you'll be the AG.
In giving that answer, you said that you asked the Attorney General if he was still the Attorney General. Why did you ask him that?
Because after he left earlier that day, we received a letter of resignation that he was going to present and apparently did present to the president. And the relationship between the Attorney General and the president was clearly strained. And there was a thought that the president might simply fire him on the spot.
Did there come a time when you had a conversation with the president about who was going to be the acting Attorney General?
Yes. After the conversation with the Attorney General, I went back to my office on the 4th floor, had a short telephone conversation with my wife, and very shortly after that, I got a call from the White House.
And tell us about what happened in that call.
It's the White House operator asking me to hold for the president. I did. President got on, sounded like he was in a good mood. He said, "Did you hear that Bill is leaving? We had a great meeting. He gave me a beautiful letter, talked about the things we did together. But now I'm going to need an attorney general. I think you'd be great in that job. Is that something you'd want to do? I think you'd be great." And I said, "Mr. President, I appreciate that, but I really do think it's best for the department and the country and you to just follow the regular procedures. We have a succession plan in place. I think you should just follow it." He said, "So that would mean that Jeff Rosen would be the acting attorney general." I said, "That's right. He'll do a great job for you." And he said, "Okay, fine. I'll call Jeff in a little while." And that was it.
And did there come a time when when Mr. Rosen got a call from the president?
He did. It was probably about 25 minutes later, 30 minutes later, something like that. He got a call from the White House.
And where were you when that happened?
I was walking into a meeting that he was at with the AGs. He was sitting at the head of the table. I walked into the meeting that was already underway. His cell phone started ringing. He looked at it. I assumed it was the White House. He looked like he wasn't sure if he was going to answer it. And I said, "You should answer that. That's the White House." And he answered the phone, said, "Yes, I can hold." Walked out of the conference room. I followed him to his office and I wrote on a Post-it note, "POTUS will ask you to serve as AG." And I left it on his desk. He nodded and I walked out.
Okay. Now, the next day, the 15th of December, did you have a meeting with the president?
Yes.
Tell us about that, please.
That afternoon, we were called over to the White House. By we, I mean the Deputy Attorney General and myself. We went over to the White House to a meeting in the Oval Office with the president, chief of staff, White House counsel, the deputy White House counsel. I think also someone was there from DHS. I think a guy named Chad Mizell, Mizell, was there. And I think he was there as a placeholder until Ken Cuccinelli switched out. I think that's everyone who was present.
Can you spell Mr. Cuccinelli's name?
Cuccinelli.
Okay. Was there any discussion in this meeting on the 15th with the president concerning election fraud investigations?
Yes, the meeting talked generally about election fraud, but was focused mostly on Antrim County and that ASOG report that I mentioned earlier.
And what about the State Farm Arena? Was that discussed in that conversation?
It may have been. I don't recall specifically. Do
you recall ever discussing that in any conversation with the
president? Oh, yes. Yeah, we had several conversations about State Farm. I just don't remember if on the 15th State Farm was really front of mind. Certainly Antrim County was.
Okay. And did you have an answer yet to the Antrim County matter?
No, because again, further to the civil litigation that was going on, the judge in Antrim County had ordered a hand recount. So by doing a hand recount, you then take the hardware and the software out of the equation. And so that hand recount was underway. The president was harping on the ASOG report, understandably, saying, 68% error rate. This is a catastrophe. If this is right, we have a huge problem, which was true because this same software and hardware is being used around the country. So we all recognize that if that was true, we had a huge problem. But I think it was Ken Cuccinelli who said, "Look, Mr. President, there's a hand recount underway. It's going to take 48 or 72 hours. That's the gold standard. That will take out any question about hardware and software. And we'll know in a few days whether this report is right or not." And so we didn't have the results at that point on the 15th, but we got them shortly thereafter.
Okay. Let me jump forward a little bit to the 21st of December. Do you recall the Attorney General Barr had a press conference on that day?
Yeah, I think it was 24th. There was the Lockerbie bombing press conference. Yes.
And what, if anything, did he say about the results of the election investigations on the 21st?
He was asked again during the Q&A portion of that press conference whether the department still believed that there was no fraud on a scale to change the outcome of the election. And he said, yes, that's right. He repeated what he'd said a few days earlier.
Now, he left on the 23rd, correct?
Yes.
And at that point was Mr. Rosen the acting attorney general?
Yes. On the 14th, some tweets were sent out by the White House that said AG Barr is resigning, and that when he left, Deputy AG Rosen would be the acting AG, and I would be serving in the role of the Deputy AG.
Okay. And in your role as, you were serving in the role as Deputy AG, what was your relationship to Mr. Clark?
I supervised him. He reported to me, as all the AAGs did, as did the U.S. attorneys and technically the FBI director and lots of other people.
All right, let's go to Sunday, the 27th of December. Where were you that day?
I was home in New York. I'd gone home for Christmas, and I was still at my home in New York on the afternoon of the 27th, planning to drive back to DC that evening.
And did there come a time when you received a telephone call from Mr. Rosen and the president?
Initially, it was Mr. Rosen. Mid-afternoon, called me on my government cell phone and said, I've been on the phone with the president for about 30 minutes. Can I threw Ray you in? He's talking a lot about election matters, and you know this stuff better than I did. So I said, yes, of course.
Okay. How long approximately did that telephone call last?
It's about 90 minutes after I joined.
Okay. And just tell us generally what the subject of the telephone call was.
The president was raising a lot of issues and allegations relating to the election. Some of these were matters that were being handled in civil litigation around the country, litigation filed by the campaign or others. Some of them were just allegations that were floating around on the internet. Some of them were things being discussed on cable news, things like that. But he had a whole series of allegations that he wanted to raise with the acting AG and me.
Did you take any notes during this conversation?
I did, because although I was trying to stay on top of all these things, the conversation started with an allegation I had not heard before. It had to do with votes cast in Pennsylvania and whether or not there had been more votes certified than had actually been cast. That was not an allegation I had heard before. And so I wanted to understand what the president was talking about, make sure I got it down right, because it sounded like something that we'd have to look at. So I began to take notes.
Did you take notes on everything that was said?
I took notes throughout the rest of the conversation. Yeah, once I started, I went through to the very end.
Okay, if you will look, please, at disciplinary. Oh, incident, I forgot to move in disciplinary council 5.
I didn't want to interrupt you. All right, so you're moving exhibit 5.
Yes.
Is there any objection, Mr. McDougall?
That's more of that control. No objection.
Okay, with disciplinary council exhibit 5 will be admitted.
Thank you, Mr. Chair. Referring you now to disciplinary council exhibit 6. Can you identify these for us, please?
Yes, those are the notes I took during that call on December 27th.
Move into evidence disciplinary council 6.
No objection.
It's admitted.
I don't want to make you interpret everything in these for us, Mr. Donahue. If you look about a third of the way down the first page, there's a reference to 205K votes.
Yes.
Could you tell us what that was all about?
So this was the Pennsylvania issue that the president started with that I was unfamiliar with. And what he said essentially was that the Secretary of State in Pennsylvania had certified about 5.25 million votes for the state, when in fact, only about 5 million votes have been cast. At certain times, the president said it was a difference of 205,000 votes. And at certain points in the same conversation, he would say it was 250,000 votes. But whatever it was somewhere between 200 and 250,000 more than the votes that were actually cast. That was the allegation.
And just to jump forward, you said this was a new allegation. Well, we'll come back to that in a second. Let's go, if we can, to the third page of this document. It's the DCX 60003. About a third of the way down the page, there's a reference to GA, which I take to be Georgia. Can you maybe read that for us and tell us what that's all about?
It says GA, which is Georgia. Tape there shows fraud. Next line says Ruby Freeman, huckster. I think to the right it says election worker. Closed the facility and then came back with hidden ballots under table. Networks magnified the tape and saw them running them through repeatedly.
Now, was this an allegation with which you were familiar?
Yes, this was part of the State Farm allegations.
And what, if anything, did you say to the president on the 27th about this allegation?
At this point, I think we'd already looked at it, and I told him that we had looked at it and it's not true.
Now, right below that, there's a sentence that says, you guys, well, maybe you could read it for me. You guys.
To quote, you guys may not be following the internet the way I do, close quote. That was a quote from the president.
Okay. If we go over to the next page. This is the page that's kind of sideways. Emily, yeah.
I see it.
Can we, Emily, can we go to page 4? Sorry, it's sideways. There's a reference in the middle of the page there. Again, it seems to be about Georgia.
It says Georgia legislature is on our side. They want to bring a case, but the governor won't let them.
And again, is who made that statement?
The president.
All right. Going to the next page, which would be page 5. There's a sentence at the top that's sort of carried over from the next page. Could you tell us what that sentence says?
Yes, starting at the bottom of the page. I noted the DAG's response, which is essentially said, look, Mr. President, we will look at this issue, obviously, but understand that the DOJ can't and won't snap its fingers and change the outcome of the election. It doesn't work that way. And then the president responded, I don't expect you to do that. Just say the election was corrupt and leave the rest to me and the Republican congressman.
And then there's some language right below that. What does that say?
This was my response to that comment. Again, it's not a quote, but I said, sir, we've done dozens of investigations, hundreds of interviews. The major allegations are not supported by the evidence developed. We've looked at Georgia, Pennsylvania, Michigan, and Nevada. We're doing our job. Much of what you're getting is false. Much of the information you're getting is false. And then I went into Antrim as an example. For instance, they told you there was a 68% error rate in the Dominion machines in Antrim County. In fact, it was 0.0063%. What they told you is not true. And then he said, okay, but what about the others? I said, well, the truck driver, they told you about the truck driver. We interviewed on both ends, meaning both ends of the shipment. There were no ballots. He couldn't even ID the envelopes, meaning the envelopes that you mail a ballot in. FBI, I think it was, showed them to him. He couldn't identify the envelopes. And he said, okay, the president said, okay, note, I didn't mention that one. I said, in Georgia, we looked at the tape, we interviewed the witnesses. There are no suitcases. We talked about how the cutters who opened the envelopes left. There wasn't multiple scanning of ballots. There wasn't double voting. Talked about Arizona. I said in Arizona, he said in Arizona, I only lost by 9,000 votes. There's clearly more fraud than that. And then he said the judges keep saying, where is the DOJ?
I think we need to go to the next page, Annalee. I'm sorry.
Yeah, I'm sorry. I'm on the next page.
Page 6.
President said the judges keep saying, where is the DOJ? Why are they not filing these cases? And then the acting AG and I took that as an opportunity to try to explain to him the important but limited role that the department has in elections, and that we don't file lawsuits on behalf of campaigns or anyone else. He had the impression in this conversation and others that the department represents the American people, and therefore, if the American people are somehow being misled by erroneous election outcomes, that they have an interest in correcting that, and the department should be filing lawsuits at least to correct that. And we explained to him that our client is the American government, not the American people, and we don't play that role. We don't do, essentially what we said to him was, Mr. President, we don't do quality control for the states. If the states screw up their elections, unfortunately, that's the state's responsibility. It's not on the Justice Department to fix it. We do criminal enforcement and we do civil rights.
By quality control, would that include something like whether signatures were being matched for mail-in ballots?
Yeah, it could be. I mean, there's a lot of procedure and process complaints about whether states were really following their own laws, because states run elections, not the federal government. States run even federal elections. And so a lot of the complaints had to do with whether the states were following their own procedures. And certainly that's of interest, but unless it rises to the level of criminal conduct, it's not something that the department gets involved in.
Now, towards the bottom of page 6 here, there's some language in quotes that start with, we have an obligation. Can you tell us what that is, what it says, and who said it?
That's a direct quote from the president. He said, quote, we have an obligation to tell people that this was an illegal, corrupt election, close quote.
And then following that, there's a reference to Mr. Clark. Tell us about that.
Yes, the president said he was obviously frustrated, and he said, people tell me Jeff Clark is great and that I should put him in. People want me to replace DOJ leadership.
And how did you respond?
I said, that's fine, Mr. President. You should have the leadership that you want, but understand that the department can only operate on facts and evidence. So changing the leadership is really not going to change anything.
And then on the next page, page 7, there's something about Fulton County at the top of the page. Tell us what that was all about.
Right. The president said, you, meaning me, he said, you should go to Fulton County and do a signature verification, and you'll see how illegal it is. You'll find tens of thousands of fraudulent votes. And then he very quickly rephrased it, and he said, I'm requesting that you go to Fulton County, because at no point did the president direct us to do anything. That was the only time he even came close to it. And then he, as soon as he said it, kind of caught himself to make it clear that it was a request and not a direction. And the acting attorney general said, understand, Mr. President, we'll take that under advisement.
Was signature validation or verification something within the authority of the Department of Justice?
If it rose to the level of criminal conduct, but routine signature validation was not something that we got involved in.
Okay. All right, so how did this conversation end?
It ended with, the president being unhappy. Obviously, he was complaining that in his view, he had won, the election was stolen from him, and the department was not doing enough about it. And we just tried to reassure him and said, Mr. President, we're doing our job. We know our job. We have a limited role. We'll continue to do it, but this is where we stand right now. And he said, can I, well, people have all kinds of things that show the fraud. Can they send it to you? I said, we'll be taking information from all sources at all times. And he asked for my cell number, which I gave him, which he had anyway, but I gave him my cell phone number at the end of the call.
Okay. At this point, how many times do you think you'd spoken to the president about these election investigations? Just ballpark.
I think that was only the third time. He called me on the 14th. That really wasn't about the election investigations. That was about the change in leadership. So we didn't really discuss that. And then we had the meeting in the Oval Office on the 15th. And this would have been the next contact.
Okay. And what was your practice with respect to how you dealt with the president about these various allegations that he would raise for you?
To the extent we were aware of them, we would say, yes, sir, we're aware of that. Thank you. To the extent we weren't aware of them, we would say, we hadn't heard that. Similar to the allegation at the start of this conversation about Pennsylvania. We'd say, okay, what is the allegation exactly? And as here, I took it down and we'd say, okay, thank you. And we would try not to give him blow by blow. We didn't want to go back to him as a candidate, as someone who has a vested interest here and say, well, we're doing this investigation or whatever it may be. When it was concluded, we would say to him, yes, we looked at that and that allegation did not pan out. It's not true. We interviewed people. We did what we had to do, but that's not true.
Okay. Just to go back to this conversation on the 27th for a moment, did you in fact go to Fulton County?
No.
And when he raised the Jeffrey Clark's name, did you understand his reference to Mr. Clark?
I knew who Mr. Clark was. I didn't know why the president was bringing up his name. It kind of struck me as odd. It came out of left field.
Okay. At the time of the call on the 27th, what was the status of the election?
This was the 27th. The Electoral College voted on the 14th of December. And so the Electoral College meets in the state capitals. They cast their votes. And then the only step left is for the votes to be certified by Congress, which was January 6th. So the election was, I think, in the view of most people, decided at that point.
Okay. All right. On the 27th of December, did you receive another telephone call as a follow-up to the one with the president?
Yes. As I was riding back to Washington, D.C. that evening, I received a call on my cell phone from Congressman Perry.
And tell us about that call. Sorry, strike that. Take a look, if you will, at Disciplinary Counsel Exhibit 7.
Yes.
Can you identify that for us, please?
Those are notes I took relating to the call I received from Congressman Perry at about 6 p.m. that night. I did mistake them the 28th. That should be dated the 27th.
I would move Exhibit 7 in evidence.
Well, I'll read my hearsay objection, Mr. Hirsch, but I believe you indicated you're going to admit over objections.
Yes. I mean, we'll take into account hearsay for what the document is worth, but it's not a basis absolutely to exclude evidence in this proceeding. All right, so Exhibit 7 will be admitted.
You said a moment ago that it was dated improperly. What's the notation in the left-hand margin there at the top?
It says approximately 1800, which is 6 p.m. It says in car en route to DC.
And just tell us what this conversation with Congressman Perry was all about.
He called, he said that the president had asked him to call me. He was concerned about the election. He was particularly concerned about Pennsylvania, his home state. He explained that he was on the Foreign Affairs Committee. He complained about the FBI and said people don't trust the FBI. He said that he likes Jeff Clark a lot, and thinks that Jeff would do something about this, meaning the allegations relating to the election.
Yep.
He repeated what the president said earlier about there being more votes certified for Pennsylvania than were actually cast. He used the number 205,000. He said that he had a forensic accountant who was drafting a report to establish this, and asked if he could send it to me when it was done. And I said, feel free to send me whatever you have. And I gave him my email address.
Did you follow up on this allegation about the 205 or 250,000 votes in Pennsylvania?
Yes.
Tell us what you did.
I think while I was still in the car, I got an email from Congressman Perry, which I forwarded to Scott Brady, Brady. Scott was the U.S. attorney in the Western District of Pennsylvania. And I asked Scott to look at it. I might have talked to him on the phone as well. I can't remember, but essentially I sent it to Scott and I asked him to find out what the situation was in Pennsylvania. And it took a couple of days, not long, maybe 2 days or so. And he came back to me and gave me the explanation for why there was this difference.
And what was the explanation?
The number that the president and I guess Congressman Perry were using came from a public-facing database called SURE, S-U-R-E. It was the State Uniform Reporting on Elections database. And it reported out the number of votes cast in each county. The problem with the SURE database was that 4 counties had not reported their results. So they were missing the ballots from 4 counties. The Secretary of State, who sent the certification to Washington following the Electoral College vote, was not relying on the SURE database. She was relying on the counties themselves to report to the Secretary of State. So she had a complete set of data, which put the votes at approximately 5.25 million. Once you rolled in the missing votes from the 4 counties, the numbers matched.
Now, following these conversations on the 27th, what, if any, conversations you have with Deputy Attorney General Rosen about Jeffrey Clark?
We talked about the fact that the president had raised Jeff Clark's name. I let the Deputy Attorney General know that Congressman Perry had raised Jeff Clark's name. We thought that's very odd. The Deputy Attorney General had a long relationship, personally and professionally, with Mr. Clark. I did not. They had been together at a law firm for many years. And so he said, I'm going to call Jeff and find out what's going on here. And he did that. I was not involved in those conversations.
Okay. Did Mr. Rosen report to you the result of the conversation?
He did. We talked on the 28th. I believe he spoke to him on the morning of the 28th. I don't know if it was in person or by phone. But it wasn't entirely clear to me what the situation was until later that day.
Okay. We'll come to that in just a second. Before we do that, did the president follow up with you in any telephone call after the one on the 27th?
He called me on the morning of the 28th, very briefly, and I don't remember the specific allegation, but it was a repeat from something he had said the night before.
Okay.
And he said, I don't remember if I mentioned this last night, but X. And I said, oh yeah, yes, Mr. President, you did mention that. Thank you. And that was it.
All right. Let's turn to the events of the 28th. Let me show you Disciplinary Counsel Exhibit 8.
I see it.
And I'll ask you to identify the first page and then the attachment to the first page.
So that is an email that Jeff Clark sent to the acting attorney general and me at 4:40 on December 28th. And attached to the email is a letter that he proposed sending out to officials in the state of Georgia.
Move disciplinary counsel exhibit 8 into evidence.
No objection.
Exhibit 8 will be admitted.
Referring first to the email on page 1, where he's asked for I'll just read this. I would like to have your authorization to get a classified briefing tomorrow from ODNI, led by DNI, Radcliffe, on foreign election interference issues. What's ODNI and DNI stand for?
ODNI is the Office for the Director of National Intelligence. That is the intelligence body that sits over the 17 U.S. intelligence agencies, including the CIA and FBI.
Okay. And DNI, I take it, is the Director of National Intelligence.
Correct.
And he goes on to say, I can then assess how that relates to activating the IEEPA and 2018 EO powers on such matters, now twice renewed by the president. What's IEEPA?
International Executive Emergency Powers Act.
And what about EO?
Executive Order.
Okay. If you have not seen it, white hackers have evidence in the public domain that a Dominion machine accessed the internet through a smart thermostat with a net connection trail leading back to China. ODNI may have additional classified evidence. Had you heard this allegation about the smart thermostat before?
No, this is the first I heard of that one.
Okay. How did these allegations fit within Mr. Clark's responsibilities?
They did. These classified issues and other issues addressed in this email did not fall within the responsibility of the civil division.
Okay. And did you have an opinion, a position on the appropriateness of his being briefed by DNI Radcliffe?
I did not think that was appropriate.
Okay. And why was that?
Because as the acting AAG for the civil division, he had no responsibilities relating to intelligence matters, election matters, or anything else that would touch upon this. So I didn't see any reason why he should be getting any briefing, much less a briefing from the DNI himself. That would be extremely unusual to have a mid-level bureaucrat in one agency briefed by the head of another department.
Okay. Let me go to item 2. And again, I'm going to read it. Attached is a draft letter concerning the broader topic of election irregularities of any kind. The concept is to send it to the governor, speaker, and president pro tem of each relevant state to indicate that in light of time urgency and sworn evidence of election irregularities presented to courts and to legislative committees, the legislators thereof should each assemble and make a decision about elector appointment in light of their deliberations. And then he goes on, I set it up for the signature by the 3 of us. I think we should get it out as soon as possible. Personally, I see no valid downside to sending out the letter. I put it together quickly and would want to do a formal site check before sending it, but I don't think we should let unnecessary moss grow on this. Did you see any downside, Mr. Donahue, to sending out the letter?
Yes, I saw significant downsides to sending such a letter.
Okay. Mr. Chair, I am going to want to go through the letter. We're at 11:20 or 12:22. It's going to take a while to do that.
I assume it would. All right, why don't we take our break now and resume with the letter after lunch? Um, just to give people an idea on the schedule today, I think we're planning to go until 5. And what I would do is try to make a somewhat shorter lunch. Maybe we're now at 22 after, so make it say 7 after 1, to come back, and then we'll take plan at some point in the afternoon to take about a 15-minute break and try to keep things moving. Are there concerns about that?
Yes, Chair. Take the full hour. I'd appreciate it, just for the reasons you know that I'm seeing.
Okay, all right, then let's be back here in place and ready to go at 1:25. Okay.
Thank you.
I can't speak to that, but maybe Mr. Turner can help.
See you here. Oh.
All right. Welcome back, Mr. Donahue.
Yes, sir.
Of course, you're still under oath.
Yes, sir.
Thank you. Please proceed, Mr. Cox.
I want to return to, excuse me, disciplinary council's exhibit 8. And Emily, I'd like to look at the second page if we may. Got my own out of order. Mr. Donahue, I'd like to go over some of the statements in this draft letter. The first sentence says the Department of Justice is investigating irregularities in the 2020 election for President of the United States. And then it says the department will update you as soon as we are able on investigatory progress. I'm going to stop there in the middle of that sentence. Is that accurate? Does the department update state law officials on their investigatory process?
We would not normally do that, no.
Okay. And why not?
Because if we're conducting an investigation, typically we don't want any outside authorities involved until we're done. There are times when it's appropriate to coordinate with state authorities, but we don't normally just update elected officials in states about ongoing federal investigations.
And then to complete that sentence, it says, but at this time, we have identified significant concerns that may have impacted the outcome of the election in multiple states, including the state of Georgia. Was that an accurate sentence?
No, not in my view.
And why was that?
Well, the concerns that we had followed up on either were addressed or were not of such significance that they would have impacted the outcome of the election, either in Georgia or any other state.
Now, there's a reference below that statement toward the bottom of this page. There's some sort of legislative report from Georgia. Were you familiar with that?
Yes, the Georgia State Senate held a hearing and they issued some sort of report afterward.
Okay. And do you know what, if any, follow-up had been made as a result of that hearing?
So do I know what?
What, if any, follow-up had been made on those allegations that came out of that hearing?
Much of what we presented in the hearing, much of what was in the report had to do with process issues. And so we're not anything that the government, that the DOJ at least would be involved in. So a lot of the complaints about how they were not following certain procedures, or they were not allowing observers to be close enough, or they were leaving ballots unsecured in certain parts of the facility and things like that, were just not things that DOJ would be involved in.
Now, if we'll go over to the second page at the top, it says, in light of these developments, the department recommends that the Georgia General Assembly should convene in special session so that its legislators are in a position to take additional evidence, receive new evidence, and deliberate on the matter consistent with its duties under the U.S. Constitution. Had the department ever made such a recommendation to a state before, as far as you know?
Not to my knowledge, no.
And what was this appropriate in your judgment?
No, not at all. As I said, the states conducted, but the states conduct elections and the department conducts criminal investigations. And it was not up to the department to tell states how they should run their elections.
Down in the next paragraph on this page, the second sentence says, the department believes that in Georgia and several other states, both a slate of electors supporting Joseph R. Biden Jr. and a separate slate of electors supporting Donald J. Trump gathered on that day at the proper location to cast their ballots, and that both sets of those ballots have been transmitted to Washington, D.C. to be opened by Vice President Pence. And you can see from the former sentence that the day they're talking about is December 14th. Was that in fact so? Was there any evidence you're aware of that there have been these two sets of electors that have voted on the same day in the proper time and proper place?
No, we're not aware of any state having legitimately selected two slates of electors. That has happened in American history, but it did not happen in the 2020 election.
And then, without going through every page of it, there's a theory that's set forth in the rest of this letter about the authority of the legislature to call itself into special session. Had that theory ever been adopted by the Department of Justice?
Not to my knowledge, no.
And before the Department of Justice would advocate such a theory, what steps would it take? Internal steps.
We would, just in terms of understanding and exploring some of these theories that were being circulated, we typically relied upon the Solicitor General's office and the Office of Legal Counsel, which is commonly referred to as OLC. OLC is essentially the brain trust for the department. So when we had different issues come up, I would typically send them to the AAGs who headed those two components and say, take a look, what do you think? Is there anything to this? And I get feedback from them.
Who, if anyone, had analyzed the consequences of the legislature calling itself into session if the state law prohibited from doing so?
I don't recall if OLC looked at that particular issue. If they did, it would have been Steve Engel, ENGLE. But as I sit here today, I can't specifically remember if we asked them to look at that. But again, our view was certainly that the department is in no position to be telling the states how they should meet their constitutional obligations vis-a-vis a federal election.
What was your response when you read this? This email and the letter dated 4:40 on December 28th. Did you receive it on or about that time?
Yes, I did.
And what was your reaction when you saw it?
I read through it twice just to make sure I understood it. And then I went next door to the Deputy Attorney General's office and he was not there. When I got to his office, I realized he wasn't there. I remembered that he had an appointment of some sort. I knew where he was. I don't recall what it was now, and so I went back to my office and then I wrote a response to Mr. Clerk.
And if you'll look next at Disciplinary Counsel Exhibit 9, do you identify that?
Yes, that's the response I sent to Jeff Clark at 5:50 p.m. on December 28th.
Move Disciplinary Counsel number 9 into evidence.
Okay.
Exhibit 9 is admitted.
In your second paragraph, you say, while it may be true that the department is investigating various irregularities in the 2020 election for president, something we typically would not state publicly, the investigations that I'm aware of relate to suspicions of misconduct that are of such small scale, they simply would not impact the outcome of the presidential election. Then you go on to say an AG Barr made that clear to the public only last week, and I'm not aware of intervening developments that would change that conclusion. Thus, I know of nothing that was worth a statement. We have identified significant concerns that may have impacted the outcome of the election in multiple states. We're always prepared to receive complaints and allegations relating to election fraud, and we'll investigate them as appropriate. We simply do not currently have a basis to make such a statement. Did there come a time after you sent this email to Mr. Clark when you had a meeting with him?
Yes, that evening we had a meeting with him.
And where was the meeting, and approximately how long after you sent this email was the meeting?
It was shortly after 6 p.m., I believe. So I sent the email and went back to the deputy AG's office. He returned from wherever he was. We had a very brief discussion. And he said that he'd already instructed one of his administrative assistants to get Jeff Clark into his conference room so we could talk to him.
And would you describe to us what happened in that meeting between you and Mr. Rose and Mr. Clark?
We had a conversation about the letter, obviously, and his proposal and why neither the acting attorney general or I believe that that was appropriate. And we talked some length about the fact that the department has done investigations. It's not as if we haven't done anything. We've done investigations. We've taken in allegations. FBI and others have run them down, and that we just had no basis to make these claims. And it went on for some time. It was a contentious meeting. Mr. Clark obviously had his own views that were different. And Jeff Rosen kept trying to explain to him that these things that he was hearing and reading about on the internet and elsewhere, I guess, were just not supported by evidence.
Do you recall what, if any, allegations Mr. Clark raised that he thought needed to be investigated?
He talked about this smart thermostat theory. I think he had read that in a civil filing, perhaps an affidavit attached to one of the civil filings done by the Trump campaign. I told him that that was, as far as we were concerned, out of left field. The IC had briefed us extensively prior to the election. By IC, I mean the intelligence community, I'm sorry. And it was just not something that we believed was true. And he, of course, was asking for the briefing from the Director of National Intelligence. There was a discussion along the lines of whether he should get that and did he have the right security clearances and things of that sort.
Aside from this thing about the smart thermostat, did he raise any other allegations that needed to be investigated?
I think he did raise others relating to Georgia, talking about State Farm Arena, again, most of which were things we'd heard of before. I do remember the smart thermostat being entirely new to me, and he may have raised some other new ones. I can't remember exactly, but there were various allegations that he was obviously interested in.
Okay. What, if any, discussion did you have with Mr. Clark about the factual basis for the letter that he proposed?
I kind of said, where are you getting this from? You're not involved in any of these investigations. You haven't been briefed on anything. Where are you getting this from? And he said, well, I've been reading the filings in the civil cases, which was clear. And he would say things to the effect of, it's all over the place. You can see it. It's all over the news. It's all over the internet. There are all these affidavits being filed, and we need to do something about it.
What, if any, discussion was there about his contacts with the White House?
So in that conversation, the acting attorney general said, you know, Jeff, we're hearing your name from the president. Rich heard your name from a congressman. What is going on here? And he said that he had met with the president. I believe he said in the Oval Office. It was clear it was recent. I don't know if he gave us a day, but it had happened within the last few days. He said, well, I went to the Oval Office. I met with the president. We discussed this. He's very concerned. He's concerned that we don't have the right leadership in place. These are trying times, and you need leaders for trying times. And he doesn't think he has those leaders right now, meaning in us. And he's thinking about making a leadership change. And it was clear from the way he phrased it that that meant that he would be part of the leadership and we would not be.
Jack, but speculate about what was Mr. Clark's head.
Well, how did you interpret it?
As I just said, that we would be out, he would be leading the department.
Okay.
I'll That was my understanding of the question and the answer, Mr. McDougall, that it was the witness's interpretation of what he said.
Okay. I think I was asking you questions about what, whether any further discussions about the appropriateness of Mr. Clark's White House contacts.
So when he indicated that he met with the president, my first reaction was, and I said out loud, "You violated the White House contacts policy." And because I was surprised. I mean, obviously his name had been provided to the president and others, but I was very surprised to hear that he'd actually gone to the White House and met with the president without telling me or the acting attorney general. So I was taken aback. I said, "You violated the White House contacts policy." And he said something to the effect of, "There's more at stake here than a policy."
And was there any discussion about that White House contact policy going forward?
I said, "Do not violate it again. You know what the policy says. You know what it requires. Do not violate it again."
And what was Mr. Clark's response?
He said that he would not.
I'm sorry, I couldn't hear you.
He said that he would not.
Would not. All right.
Right.
How did the meeting end?
As I said, it was fairly contentious, but the takeaways were that he was supposed to go get this briefing from someone at ODNI. And the idea was that he would presumably hear what we had heard before the election, which was that there was not significant reason to be concerned about foreign intelligence interference in the election. The second takeaway was that he was supposed to call the U.S. attorney in Atlanta to discuss with him the investigation that had been done in connection with the State Farm arena allegations, so that he could see that we actually looked at it. We actually interviewed the witnesses. We actually looked at the tape, and that we determined that those allegations were not well-founded.
After the meeting, did you inform anyone else about the fact of the meeting?
Late that night, I sent an email to Steve Engel, E-N-G-L-E, telling him that I wanted to talk to him before the morning meeting the next day to inform him about some things that were going on.
And if you'll look at Exhibit 10, can you identify that?
Yes, that's the email I sent to Steve at 11:41 p.m. on December 28th, asking him to show up 10 minutes before the meeting so I could talk to him.
I move Exhibit 10 in evidence.
Exhibit 10 is admitted.
And why did you want to talk to Mr. Engel about this?
If you follow the DOJ succession memo, when the attorney general is no longer in the department, the deputy attorney general takes over, and so on. It goes down probably about 8 positions. In doing that analysis, you remove anyone who's acting. And so if you follow that memo down, if Jeff Rosen were removed from the attorney general's position, by default, Steve Engel would have become the acting attorney general. The president could have put someone in that seat, but absent the president doing that, Steve would have become the acting attorney general. And because of that, I want to make sure that he was aware of what was going on in case he ended up in that seat unexpectedly.
And did you and Mr. Engel meet the following morning?
We did. Yeah, we spoke, just before 9, and I gave him a very brief recitation of the phone call from the 27th and the meetings and the emails on the 28th.
After the events of the 28th, did you have any subsequent communications with the White House concerning the possibility of election fraud violations and Mr. Clark's involvement therein?
Yes, we had a number of communications with the White House. We went over and had a meeting at the chief of staff's office at one point. that did not involve the president. And then we had another meeting in the Oval Office on January 3rd.
Okay, we'll come to that in a moment. Take a look, if you will.
I'm sorry, I should also say we had at least one phone call from the president. I think that was on the 30th, but I could be wrong.
Take a look, if you will, at Disciplinary Counsel Exhibit 11. Now, I know you're not shown as copied on these emails, but my question for you is, did you in fact see these emails around the time that they were written?
Yes, I think I did.
Okay. And how would you have seen them?
I think either Jeff Rosen forwarded it to me or he showed it to me.
Okay. And at the top, the emails from Mark Meadows. Who is Mark Meadows?
He was the president's chief of staff.
I move Exhibit 11 in evidence.
Exhibit 11 is admitted.
And on the 30th of December, Mr. Meadows writes, Mr. Rosen, can you have your team look into these allegations of wrongdoing, only the alleged fraudulent activity? Now, did you understand what these allegations of wrongdoing were that he wanted you all to look at?
Well, there were a lot of allegations in the litigation arising in Georgia, some of which were process issues, as I mentioned earlier. In fact, most of which were, and I guess there were some allegations of criminal activity here. You'll note that he says only the alleged fraudulent activity. I think that's because we had explained to him our limited role, the department's limited role.
In the email beneath that from Cleta Mitchell to Mark Meadows in the third paragraph, there's a reference to the video issues in Fulton County and the equipment. Did you understand what that, what was your understanding of what that meant?
I knew there was a video of the interior of State Farm that some people claimed showed that fraudulent ballots were brought into the facility and processed and so on. There have been clips of that video being played on news outlets and on the internet. We had the FBI go back and watch the entire, I think it was 15 hours of video, and interview the people who were on the video as part of that investigation.
And that had been done already?
By the 30th, I think that had been done.
Okay.
Mr. Hirsch, I will object to this extent. I'm refrained because I know they're being liberal with admitting these exhibits, but this is neither from nor to Mr. Donahue, number one. And number two, the reference to video issues is completely undefined. The witness is making an assumption about what it refers to, but there's no tethering. There are other video issues at Fulton County, such as videos of drop boxes. And we can't tell from this document, and the witness is speculating about what this other person is referring to.
I don't see those objections as a reason to exclude it. You can ask about it in cross-examination if that becomes relevant. And there isn't a requirement that a witness have actually received a document in order to give relevant testimony concerning it. So I'll overrule the objection.
Now, Mr. Donahue, let me refer to you, Disciplinary Counsel's Exhibit 12. You recognize this document?
Yes, sir. This is an email chain from January 1st, 2021, involving myself and Jeff Rosen and others.
Okay. And I'd move Exhibit 12 in evidence.
Absolutely no objection to that.
Okay, Exhibit 12 is admitted.
Okay. You'll see in the middle of the page, there's an email dated January 1 from Mr. Meadows to Mr. Rosen that says there have been allegations of signature match anomalies in Fulton County, Georgia. Can you get Jeff Clark to engage on this issue immediately to determine if there's any truth to this allegation? And then immediately above that, I take it that somebody wrote, "Can you believe this? I'm not going to respond to the message below." Who wrote that, you know?
Mr. Rosen,
And to whom did he write it?
to me.
Okay. And then above that, you say, "At least it's better than the last one," but that doesn't say much. Why was the issue of signature match anomalies in Fulton County not worthy of responding to?
It wasn't so much the signature match in Fulton County, it was the involvement of Mr. Clark. Because we had explained to the chief of staff that Mr. Clark did not have a position within the department that would involve him in criminal investigations. Nor did he have any criminal investigation background or experience. And so we thought that had been sort of put to rest. But yet, again, we're receiving emails where they're specifically asking to have Jeff Clark handle election-related issues that are at least potentially criminal. So that's what he's reacting to when he says, "Can you believe this?" It's not the Fulton County signature anomaly issue.
Now, I want to go now to December 31st. Actually, I guess I'm going back slightly, but was there a meeting at the White House that you attended on the 31st?
Yes, sometime mid to late afternoon.
And with whom was that meeting?
President, chief of staff, White House counsel, the deputy White House counsel, myself, and Mr. Rosen.
And what, if any, discussion was there about these election investigations at that meeting?
There was a further discussion about the election investigations. I think we talked about Antrim County because at that point we had the results. The president was obviously very frustrated and wanted the department to do more. And he brought up other allegations. I don't remember exactly all of them, but he went through a string of allegations, mostly in swing states, Georgia, Pennsylvania, Nevada. And he just wanted to impress upon us that he felt we need to do something.
And what was your response?
We again said, "Mr. President, we understand to the extent we get allegations and they appear to be credible, we're looking at them, we're doing our job." And he again made some reference to maybe I don't have the right leadership. And we said, again, you should have the leadership you want, but it's facts and evidence and they're not going to change.
And was Mr. Clark's name mentioned at all during this meeting?
I think it was.
All right, that was the 31st, I guess, New Year's Eve. What was the next time that you had a meeting or a discussion with Mr. Clark about these matters?
It was on January 2nd.
And can you tell us about that? That was a Saturday, correct?
That was a Saturday, yes. I was in my apartment in DC. The acting attorney general called me on my cell phone and he said, "Can you come to the office?" Jeff, I spoke to Jeff this morning, Jeff Clark, and I need you to just come over and help me figure out what to do with this situation. And so my apartment was only a few blocks from the Justice Department. I said, "I'll be there in 15 minutes," and I walked over.
And did you, in fact, meet with Mr. Rosen when you got there?
I did. I met with Mr. Rosen in his office. We talked. He recounted some of his conversation from earlier that day with Jeff Clark. I think they met in person, if I remember correctly, according to him. And there was going to be another meeting that day. And Mr. Rosen asked for me to participate in that meeting. He didn't want to do that meeting alone.
And did there come a time when you and Mr. Rosen and Mr. Clark met?
We did. We met in the SCIF, SCIF, on the 6th floor.
You better explain to these folks what a SCIF is.
Secure, compartmented information facility. It's where you can discuss classified information. So you leave your phones outside. There's no ability to record anything. Nothing can be intercepted, et cetera.
And at that meeting, was there any discussion of an intelligence briefing that Mr. Clark had received?
Yes, that was the first question I asked him. Did you get your ODNI briefing? And he said, yes. What did they tell you? And he recounted what they told him, which was the same as they had told us prior to the election.
And did Mr. Clark raise any further issues about foreign interference?
Not after that, no.
Okay. Now, you also mentioned earlier, Mr. Clark having discussions with the U.S. Attorney in Georgia. Did that subject come up at this meeting?
Yes, that was my second question, because those were the two takeaways from the prior meeting. He did get the briefing. I said, fine. Did you talk to BJ Pack? It's the first name is Byung, B-Y-U-N-G. Middle name is Jin, J-I-N. Last name is Pack, P-A-K. Commonly referred to as B capital J-A-Y, BJ Pack. I said, did you talk to BJ? Did he tell you about the investigation at State Farm Arena? And he said, no, he had not called BJ.
Did he explain why he had not called Mr. Pack?
No.
What, if anything, did he tell you that he had done?
He had interviewed a witness over the phone who he described as the largest bail bondsman in Georgia. I think he said the individual also owned a telephone company, and that this individual had been doing some investigations of his own and had some video surveillance of shred trucks at an election facility. And I think he had talked to some other people, but it was clear he was sort of conducting an investigation on his own.
And what, if anything, did he tell you about allegations that might have affected the outcome in Georgia?
I think we'd asked him whether, so what they say, what'd you find? And again, it was nothing that to me sounded like it was credible or could be corroborated in any way. And he essentially said, well, I think we should just send the letter anyway. And then we got back into a discussion about whether the letter would be sent and who would send it and all of that.
And what was your position on sending a letter?
I said, absolutely not. And now you should know better than you did a few days ago why that letter shouldn't be sent. ODNI briefed you. Even with your own investigation, you can't find anything substantial. And you didn't talk to the people who actually conducted the investigation related to State Farm Arena. And if you had, they would have told you that it's not substantiated.
Did the subject of a leadership change at the department come up in this January 2 meeting?
Yes.
Tell us what was said about that.
So Mr. Clark said he had again spoken to the president. My immediate reaction was, you again violated the White House policy, contacts policy. There was some discussion about that because Jeff Rosen was very upset that he had committed in the earlier meeting to not do that, and he did it. He said that he'd spoken to the president, that the president was interested in making a leadership change, that the president had offered him the position of Attorney General.
Him being Jeff Clark.
Yes, that he would be the acting Attorney General. And that he had committed to give the president a response by Monday morning. So this was Saturday afternoon or Saturday evening. And he had committed to give the president a response by Monday morning, but that we could avoid all that if Mr. Rosen and I would agree to sign on to the letter.
And what was your response?
Absolutely not.
And how did that meeting end?
It was a contentious meeting. Everyone was angry, and there was nothing left to be discussed at that point. And we all walked out of the skiff, picked up our telephones from the secure box. He went his way, and Mr. Rosen and I went back to Mr. Rosen's office.
Now, did you make any notes at this meeting?
I did, yeah,
Could you look at disciplinary counsel exhibit 14?
yes,
And are these your notes?
yes, they are.
I'd move disciplinary counsel exhibit 14 in evidence.
Exhibit 14 is admitted.
And just about 2/3 down the page, there's it's a third from the last paragraph. There's something that begins DAG. Could you read that to us? What's
It says DAG, and I make it clear that the department will not send out such a letter as long as we are in charge of it.
in the upper left-hand margin, there's some stuff that's cut off, so perhaps it may not be legible for the committee. Could you just interpret and tell us what is written there?
The first one says acknowledges that he did not call BJ Pack as he was told to do. I'm sorry, as he was told to. The second one, the first word is cut off, but it says, it looks like it says federal law requires that ballots be preserved for 22 months.
Is that a reference to the shredding allegations that you told us
Right.
about?
Yes.
Okay. And then at the top with a number 1 beside it, there's something that looks like it says DNI briefing. Could you read that to us, please?
It says number 1, DNI briefing, no underlined evidence of ballot/data tampering in IC, which means the intelligence community. Underneath that, it says influence only, meaning that the reporting from the intelligence community was that foreign intelligence services would try to influence the US election, but would not be interfering to the extent of trying to change data or ballots or anything like that.
And then right below that, there's a 2 that's circled and a GA, which I take it stands for Georgia, and then some stuff that's written there. What did you interpret that for us, please?
It says GA. Above that, it says JC, which is Jeff Clark, has interviewed him over the phone. Next to GA, it says largest bail bondsman in Georgia and has own phone company. Beneath that, it says he called head of GBI, which is the Georgia Bureau of Investigation. It says not interested. Below that, it says then called Bobby, Bobby, Christine, Chrisstine, who is the U.S. Attorney in the Southern District of Georgia. Next to Bobby Christine's name, it says, but nothing done. To the right of that, an arrow down from the bail bondsman entry, it says conducted surveillance on warehouse on King Street. Thinks he saw trucks move ballots to shredding location.
Okay. All right, thank you. Now let's move on to the following day, January 3. Did you go to the department on January 3?
Yes, we had a series of meetings scheduled at the department mid-afternoon in preparation for January 6th. Those meetings were with the Department of Defense, Department of Homeland Security, and others.
And did you personally meet with Mr. Clark at the department that day?
No, I did not.
Did Mr. Rosen meet with him?
I can't recall if he met with him in person or talked on the phone. I think he met with him in person that morning, but I wasn't there for that. He just relayed it to me.
And after the meeting, did you have a conversation with Mr. Rosen?
Yes.
And what did Mr. Rosen tell you?
Before we started the conference call with the other agencies, he said, I had a meeting with Jeff Clark. he gave a very brief explanation. He said, I need you to stick around when these calls are done. We finished the calls and then he gave me a more detailed explanation of his discussion with Mr. Clark.
And what did he tell you that happened?
He said that Mr. Clark had decided to take the president up on his offer to serve as acting attorney general. And that he was relaying that to the White House that day. He wasn't going to wait until Monday morning. And that the expectation is that Jeff Rosen and I would be removed from the department that day.
What, if any, action did you take once you learned about this?
I went next door to my office and I began taking things off the wall, packing up boxes to leave.
Why'd you do that?
Because I assumed we were about to be fired by tweet or some other means, and I just wanted to have my stuff packed up.
Okay. And then did there come a time when you decided to take some other action?
Mr. Rosen came to my office and he said, I just spoke to Pat Cipollone, Cipollline, who was the White House counsel. And he said, I just spoke to Pat Cipollone. Pat says he does not think this is a done deal and that we should go to the White House and fight for our jobs. And I said, sir, I'll do whatever you want. And he said, let's see if we can get a meeting with the president. And then he went back to his office. I continued doing whatever I was doing in my office. I think I stopped packing and was working on paperwork, but I stayed there. And then he later communicated to me that we had a meeting scheduled for 6:15 at the White House, but that Jeff Clark had stipulated that he would only attend the meeting if I was not present.
And before you went to that, before that meeting at the White House, what, if any any other action did you take?
So I said, okay, based on that, I assumed I was not going to the White House meeting. And I said, what do you need me to do to get you ready? And he said, Jeff Rosen said, I think it's time we let the AAGs know what's going on. Can you get on a call with them, tell them what's going on, and try to find out what, if anything, they would do. Find out if they would resign.
AAGs being Assistant Attorney General.
Correct.
Okay. And did you in fact do that?
I did. Pat Hovakimian, Hovakiamian, was one of the DAG's staff members. He'd previously been his chief of staff. Pat came in and he and I began contacting the various AAGs to try to get them on a conference call so we could brief them.
And did such a call occur?
Yes, I think around 4:30 or so.
And tell us about what happened on that call.
We managed to get all the AAGs but one, including the acting. So like the acting Solicitor General, I think, was on the call. So we had maybe 6 or 7 people on the call. And I said, look, I just want to explain to you what the situation is here. We've not shared this with you previously because we want you guys to be focused on the mission, but there have been some developments over the last few days, and there may be a leadership change in the department, and we want you to be aware of it. And then I went and gave them a brief explanation of what had happened with Mr. Clark, the fact that Mr. Clark had had conversations with the president, the fact that Mr. Clark wanted to send out a letter that we did not believe was accurate. And I said, I don't need to know what you're going to do about this, but give it some thought. And if you know that you're going to take some action if Jeff Rosen is removed and Jeff Clark is made the acting attorney general, call me, text me, email me, and let me know. But no pressure to make any decision. But if you do make a decision, you have a thought, it will be helpful for me to know. And then immediately, the AAG for Civil Rights, Eric Dreiband, Dreiband, said, I don't need to think about this at all. I will resign. There's no way I'm going to stand around for that. And then the other AAGs all began chiming in. Me too. There's no way. I'm not staying for this. And then basically everyone on the call said, you know, we're going to resign. Let us know if this happens. If this happens, we'll all resign tonight.
Now, later in the day, there was a meeting at the White House. Were you present?
Yes, the meeting was scheduled for 6:15. The acting attorney general was getting ready to leave just before 6. He was going over with his security detail to the White House. And I was basically wishing him good luck. And he said, no, you're coming with me. And I was not dressed for the White House. I was not expecting to go to the meeting. And I said, I thought I wasn't going to the meeting. He said, no, I need you there. You don't even need to come into the Oval Office. Just sit outside. But if there are questions that I can't answer, I'd like to have you there. So I got in the vehicle and went with him.
All right. And what happened once you got to the White House?
We went to the West Wing. We went through the normal entrance procedures. I sat on a couch down the hallway from the Oval Office, and the Attorney General proceeded down to the Oval Office, I think with Pat Cipollone.
And did there come a time when you joined that meeting?
Yes. While I was sitting on the couch, the chief of staff came down the hall, going in the other direction. He just nodded and said, good luck. It's clear he had just left the meeting. And then about 25 minutes after I'd been sitting on the couch, one of the administrative assistants passed by and said, are you supposed to be in this meeting? And I said, no, I'm just here in case there's a question that no one else can answer. And she said, okay. And she left. And then within a minute, she turned around, came back and said, the president wants you in the meeting.
And so did you join the meeting?
Yes.
Who was present in the Oval Office when you joined?
Pat Cipollone, Pat Philbin, both in the White House counsel's office. Eric Hirschman, Hershmann, I think is the right spelling. Jeff Rosen, Jeff Clark, Steve Engel, and the president.
And would you please tell us what happened at the meeting after you arrived?
I proceeded to the couches that are set away from the president's desk to try to sit back there, and they all sort of laughed and said, no, you're up here with the rest of us. And the president said, make room. And they put a chair directly in front of the president that I took, sitting between Jeff Rosen and Jeff Clark. And then they were obviously in the middle of a conversation about the election and about leadership change. And I sort of joined the conversation from there, but it went on. It was mostly focused on leadership change, not so much the specifics of the election investigations.
What did the president say about you and Mr. Rosen and your leadership?
He said that we had failed to do our job, essentially.
And what was the position of the various people in the meeting as to whether Mr. Clark should replace Mr. Rosen as acting attorney general?
Everyone in the meeting except Mr. Clark and the president were opposed to that. The president was deciding. He wasn't advocating one way or the other, but everyone else was advocating against the replacement.
And what were the arguments, and if to the extent you can attribute them to an individual, that were made against Mr. Clark replacing Mr. Rosen?
So Mr. Rosen and I essentially said, look, we've done our jobs. We've done the investigations. They didn't pan out. That's just the way it is. We did the interviews. We did the searches. We did everything we ought to do. And the fact is, people are telling you things that are not true. And they have been for some time. And the White House counsel was basically saying this is a terrible idea. You will undermine confidence in your administration. In reference to the letter, Pat Cipollone said that letter is a murder-suicide pact. We shouldn't want anything to do with that letter. I wish he'd never even written that letter. Eric Hirschman was saying essentially this guy will never be able to do what he says he can do. Mr. Clark was basically saying that he was going to conduct these large scale nationwide investigations in record time within a few days, and he was going to uncover significant fraud that was going to completely change the outcome of the election. That was completely unrealistic. So Hirschman was making that point. We kind of went round and round. It was a very contentious discussion. Voices were raised. It was some impolite language, of course, and everyone was making their views known. And at one point, the president said, "What do I have to lose? You know, you're telling me I'm going to lose this election anyway. What do I have to lose if I put this guy in? At least he can give it a shot." And I said, "Mr. President, you have a great deal to lose. You're going to lose your leadership. No one cares about us. You'll remove Jeff Rosen. No one cares about me leaving. You're going to lose your entire leadership. All your AAGs are going to resign. And these are your people. You put them in. They're not holdovers from a prior administration. These are your people. You sent them to the Senate. You got them confirmed. They believed in your administration, and they're going to walk out because of this. And I don't know what the U.S. attorneys are going to do. I know them all. You're going to lose a significant number of your U.S. attorneys. They're not going to stand for this. And you are looking at the prospect of mass resignations across your Justice Department within a day or two. And that's a lot to lose." And then that triggered the president to turn to Steve Engel. And he said to me, "So what if I do this? What if I replace him with him," meaning Jeff Rosen with Jeff Clark? And I said, "I resign immediately. There's no way I would work for him." And then the president turned to Steve Engel and said, "Steve, you wouldn't resign, would you?" And Steve said, "Mr. President, I've been here through multiple AGs. I've been with your administration from the beginning, but I couldn't stick around for this. I would resign." And so the conversation went along the line of the price to be paid for making this move.
And what, if anything, was there any discussion of what the White House counsel would do if Mr. Clark was appointed?
Yes. Pat Cipollone said, "And I'm not sticking around. There's no way I'm going to be staying around if this is going to happen. So I'm out as well." And then, Hirschman was saying, "See, this is a disaster. This is a disaster in the making. No good will come of this." So the conversation went back and forth. And of course, Mr. Clark was saying, "Well, if we have to suffer some resignation, so be it. We'll get the job done."
Tell us how the meeting concluded.
It went on for about 2.5 hours from the time I entered. So it was about a little after 9 p.m. The president finally, in the last 15 minutes or so, had clearly made up his mind. He said, "This isn't going to be worth it." He said, "This is not going to be worth the breakage," which was a term someone else had used earlier. Not me. I can't remember. Maybe Pat Cipollone. And he said, it's not going to be worth the breakage. You're not going to be able to get anything done. The bureaucracy will eat you alive, and it's not going to work. And so we're not going to do this. And at that point, Mr. Clark began imploring the president to reconsider. He said, "History's calling. We can do this. We can get it done. Just put me in charge. I'll get it done." And then the president sort of doubled down and said, "No, I already said I'm not going to do it."
After the meeting concluded, did you have a further conversation with the president? Telephone conversation.
That night, we went back to the department. And then I went back to my apartment. And about 11 p.m. that night, I got a phone call from the president. He wanted to let me know that he'd received information that there was a truck in Georgia that was in the custody of a HSI, Homeland Security Investigations agent, whose name he had. And that he thought that the truck might contain fraudulent ballots or shredded ballots or something to that effect. And I said, "Well, Mr. President, HSI is not part of DOJ. We work with them all the time. If there's an issue, I have no doubt they'll bring it to our attention. And he said, okay, can you just let Ken Cuccinelli know? Because Ken was at Department of Homeland Security, which sits above HSI. So I said, sure, I'll let Ken know. I'm sure he could find out what's going on there. And so I reached out to Ken Cuccinelli and I let him know what the president told me.
How long did you remain at Maine Justice?
Until the end of January, when I came to the paydeck position, I was a career employee. So I was the highest ranking career employee in the department. So when the administration ended on January 20th, unlike the other people who had held political positions, I did not have to leave. I always intended to leave, but as a career employee, I was still on the payroll. So I was there on the 20th. I was there on the 21st. But after that, the new administration was in place. I didn't have any responsibilities or position. I stayed here in DC until the end of January, and I returned to New York at that point.
Thank you. I have no further questions. Is this witness?
Why don't we take a break before the cross-examination? Make it a relatively short one. Absolutely back in your seats by 34 after, which is 15 minutes. Thank you.
Sure. No worries. One 34. I think it'll be an hour. Might be less than an hour. Might be less than in terms of my own. But I'm glad we're doing the committee. I agree. Good. Good. This particular is actually the same story. It's a good law. I think we had the argument in the executive, yeah, that we will bring that kind of right. Thank you. We work with folks. Church, Jason Paul. Okay, this is even the thing we will be. This is going to get. Okay. I guess you resume. We're ready? I'm not in yet. Well, she'll let me in just a second. I think I can go ahead and start. You can start.
You should be joining.
Oh, I see. I'm in now. Good afternoon, Mr. Donahue.
Good afternoon, sir.
And we've only met in the hall before.
Yes, very briefly.
All right, sir. You were asked a question about a point in the draft letter. And I believe your answer was to the effect of that DOJ had not previously adopted that legal theory before.
Yes, I think it was about the electors theory. I'm not aware of the department.
And
getting
so
involved in that.
at least that particular issue, that was a matter of legal opinion.
Yes, I think that whether this theory holds water under a constitutional analysis, that was something that we needed others to weigh in on.
Okay. Now, you also indicated a couple of times that DOJ had no business telling states how to run their elections. Did I hear that correctly?
Essentially, that's right. Yeah.
All right, sir. Are you aware of a lawsuit that was filed by the Biden administration against the state of Georgia to invalidate election legislation that they adopted after the 2020 election?
I am aware of that generally. I didn't look at any of the filings. I believe it was done under the Voting Rights Act, the VRA.
So would it be fair to say then, at least in that instance, that DOJ did think it was their business to tell the state of Georgia how to run their elections?
When it comes to enforcement of civil rights legislation, yes, we do have a role. That's true.
Sir. Do you recall any discussion in the pre-election period about security vulnerabilities of the Dominion system?
We received a number of briefings leading up to the election, both from the intelligence community and others. I don't recall, as I sit here today, where the Dominion itself was specifically discussed. It was sort of discussed after the election. I can't remember, as I sit here, whether it was prior.
Were you aware that a federal district judge in Atlanta, Amy Totenberg, had issued an order in October of 2020 holding that the Georgia Dominion system was not secure and did not comply with Georgia law?
I don't recall that coming up in any of our briefings.
You were asked a series of questions about whether there was any support for the positions that Mr. Clark took in the draft letter, and in particular about whether there was any basis for the Department of Justice identifying significant concerns and irregularities.
Yes.
And the letter itself cites to a press article and the so-called Ligon Committee report. Recall that?
Is that the Georgia Senate Committee?
Yes, sir, it
yes.
is.
I do recall that. Yeah.
All right. And Disciplinary Counsel asked you about that State Senate Committee report.
Mm-hmm.
And I believe your answer was to the effect that those were process issues and they were not appropriate for the Justice Department to be looking into or doing anything about. Is that a fair summary?
Generally, that's right. I mean, to the extent that they were talking about procedures under state law, that was just not an issue for the department.
All right, sir. And did you read that report, that State Senate Committee report?
I don't know if I read the whole report at the time. I do remember watching some of the proceeding. I don't think I watched the whole proceeding, but I definitely watched some of the testimony, and I was aware of the content of the report. I don't know if I sat down and read the whole report at that time.
And did you notice or do you recollect that the report recommended that the legislature convene and withdraw the certification of the Democrat electors?
I do remember that, yes.
Hello.
And that they indicated they had ample evidence for questioning the legitimacy of the election in Georgia.
That was the gist of that Senate report, yes.
Sir. Now, did you read the press article that was linked in the letter?
I don't recollect if I did. I think when he sent it to me, If that link was live, that I probably did, but I can't say specifically.
All right. Now, you also indicated that in one of your conversations with him, that you asked him where he was getting this from, speaking generally, and that he answered that he had been reading filings in civil cases.
Yes.
And that reading it on the news and the internet, that it was everywhere.
Yes, that was in the December 28th
All right, sir.
conversation.
And so
Yes, I can hear you. Can you hear me?
you didn't think much of the factual basis of what he was telling you, but it would be
I'll
fair to
take the
say
jacket
that
off
he
when it's
had one,
time.
wouldn't it?
To the extent that these claims related to process issues,
It
non-criminal
is cold.
process issues, I didn't think he had any basis.
They're not
Because
tall
the
enough.
department had no role. But it was clear that he believed these things. He seemed to accept what he was being told.
So as far as you could tell, he was sincere in the views that he articulated to you.
He appeared
Say
to
that
be,
again?
yes.
All right, sir. And I'm not trying to belabor the point, but what you said just now was, I thought, I want to make sure that I understand it. He didn't have a basis on process-related issues because that was out of bounds for any DOJ employee.
Yes, I think that's generally right. In terms of being a DOJ leader and accomplishing the DOJ mission, we're limited to our scope. Scope is much broader. I understand that. Other people have concerns, but I was focused only on what the DOJ should be doing.
And that was limited to criminal investigation.
And civil rights matters.
All right, sir. And if it was outside of the ambit of those two
Hi. Yeah, I can
matters,
hear you.
it was no business of the Justice Department as far as you were
Can you
concerned.
hear me?
It was no business of the Justice Department to tell the state whether their election got it right.
And therefore, regardless of what
Oh, yeah, yeah.
quantity of
Sorry.
evidence Clark
Yes,
might
of
have
course.
seen
Yes.
or amassed
The
or
Francis Key
reviewed,
Scott Bridge.
it didn't
Aye, aye.
count as far as you
What
were
are you doing?
concerned.
Correct, for the Justice Department's purposes, that's right.
All right, sir.
Hello, 1, 2, 3, 1, 2, 3. Francis Scott Bridge collapsed at 1:30 a.m. this morning. Yeah, I can hear you. Of course. Say that
All right,
again?
sir. Have you ever reviewed the charges
okay.
that were filed in this bar case against Mr.
Perfect.
Clark?
301.
I reviewed them late last week because I just recently received them.
Okay. Now, the charges allege, and I'm gonna quote it to you, and hopefully you'll take my word that I'm reading it right. In paragraph 5, that, quote, by December 1, it was apparent to Mr. Donahue that there was no evidence of election fraud or irregularities that could have potentially affected the outcome of the 2020 election.
Hold on.
And so my question for you, sir, is wasn't it the case that the department had only investigated fraud and not irregularities as distinct from fraud?
Yes, and that's a good point. We don't investigate irregularities.
All right, sir.
Generally.
And so you did not have a position on irregularities as distinct from fraud.
I think that's fair.
And so the allegation that you did is incorrect, isn't it?
Excuse me, are you saying the allegation that, oh, I see, I'm sorry. I was misunderstanding your
Yeah.
question. I thought you were saying he was making the allegation. as
I'll try to clear it for the record then, Mr. Hirsch. If you were not clear, I need to be more clear.
Sorry.
The allegation was that you had found no evidence of election fraud or irregularities. And that's the allegation. So when it alleges that you had a position that there were no irregularities, it's not correct.
I think it would be more specific to say simply fraud and not irregularity. So I agree with your statement.
Thank you. And that was Mr. Rosen's position as well, correct?
Yes,
And before him, Mr. Barr.
I believe so. Yeah.
Jesus Christ.
You saved me quite a few questions.
Happy to help.
Yeah, they're like on my face. Yeah.
The charges allege in paragraph 6 that on December 1, 2020, and again on December 21st of 2020, Mr. Barr publicly announced that there was no evidence of election fraud or irregularities that would have altered the result of the 2020 election. So it's the same answer. Mr. Barr didn't have a position on irregularities at the time.
Well, I just refer you back to his statements. I know that December 1st was relayed by a reporter, so you've got that issue. But on in the press conference, that's video. So the AG said whatever you said. I don't know if he said irregularities or not, but
in the press report, he's reported to have said that people were confusing using the criminal justice system for allegations that should be made in civil lawsuits, and that the remedy for those type of complaints
I tell Charlie
would be a top-down audit conducted by state or local officials, not the Justice Department. Is that consistent with your understanding?
I'm off
Yes, it
center.
And if they want the Department of Justice to come and investigate, there has to be a crime to investigate, or a reason to believe there is one.
Better.
reason to believe
Thank
that there
you.
was criminal conduct or a civil rights violation.
All right, sir.
Yes.
Thank you.
Yeah, the structure of the bridge, there's some questions about the structure of the bridge, protective.
So anytime the charges against Mr. Clark alleged that the department had taken a position on irregularities, that would not be correct.
I think phrased that way, that's beyond the scope of what the department was looking at.
And so the allegation would not be correct.
I think it's beyond what the department, to the extent it says fraud and irregularities, certainly we looked at fraud.
Right.
And it's correct to that extent. Irregularities is a broader term in my mind. So I think that's beyond what the department was doing.
Also, if
and
there's
what
any
beyond
chance
what
you
the
can
department had concluded.
up the volume
Right,
on
sir.
my
But my
earpiece,
question
that'd be
was,
great.
if the allegation in the charge is that the department took a position on irregularities, that's incorrect, isn't it?
Yes.
I will just point to our recent investigation of
Now,
which took on
the department has other enforcement remedies beyond purely criminal enforcement.
Yes.
Oh, better.
And
Yes.
that would include
Thank you.
criminal, civil tools.
Yes.
And the department can make public statements on issues if it chooses to.
Within the limits of the ethical rules
Right.
applicable to lawyers, yes.
Was it a policy decision to not use non-criminal tools with respect to the 2020 election?
No, because the non-criminal tools are fairly limited themselves. As I said, you could bring a civil rights action if you feel, for instance, that certain classes of people were discouraged from voting or prevented from voting. You could have conduct that doesn't rise to the level of criminal conduct, but that the department has an interest and a statutory authority for.
Mm-hmm.
So, but that just wasn't an issue. I mean, that wasn't coming up as certain classes of people are being kept from voting.
Okay. So is it correct then that you, in your position, you never saw an issue that was appropriate for a civil enforcement remedy or a civil remedy?
Correct.
Is that a topic about which lawyers might disagree?
I think the department's role is
Yeah.
fairly well
That was
defined,
okay.
so I
But
don't
right
think there's
now
a
I
lot
have
of
a
room
press
for
conference
disagreement.
behind me, so
But
they have
look, we
the
did
speakers
talk
on.
to people within the department. Certainly, the president misunderstood our role, so we tried to clarify that for him, and he's not an attorney, so that didn't surprise me. So when it came to the department itself, it was clear that we didn't have standing to bring lawsuits, for instance, that some people were suggesting that we bring.
would you agree that if the facts of the case supported a civil rights violation of some kind or description, that the department then would have enforcement authority, either civilly or criminally?
Objection. These are hypothetical questions, and I don't see the relevance of them.
Well, yeah, it is, but I think it's exploring his earlier testimony, so I'll allow it.
Thank you.
Yeah, it would be very fact specific, obviously. We'd have to do the analysis like we would with any case, any piece of litigation, criminal or civil. But potentially you could have that, sure.
All right, sir. Now, you also talked earlier about some internal debate or disagreement regarding Mr. Barr's
Just in time, they're
post-election
wrapping
memo
up the
from
press conference.
November 9th, authorizing investigation of election matters.
Yes,
And Mr. Barr's memo was objected to by certain members of the department, correct?
yes,
They disagreed with the policy decision to investigate those matters in that time frame.
they did, yes.
And that was, you were part of that debate in some way, correct? In conveying the Attorney General's policy decision.
Yes, I thought the Attorney General's decision was clearly the right one. I think history has proven that to be
Is my
the
earpiece
case.
okay?
But at the time, I was receiving complaints
The earpiece. Is it
from
okay?
directly and indirectly from people in the department saying, can you
Okay.
talk to the Attorney General and get him to change his mind, essentially?
And did he change his mind?
No,
Did any of the people that disagreed with the policy and urged him to change it face disbarment proceedings in the DC bar, to your knowledge?
Objection. He doesn't. He would know who was investigated, and
I asked to his knowledge.
that's purely a rhetorical question.
Well, it is, but he may have no knowledge of it, or he may know about it, or whatever. I'll allow him to answer it for what it's worth.
I don't have any knowledge of any such disciplinary proceedings.
Did you report any of the people that disagreed with Mr. Barr's policy change to
No,
the DC bar?
no, but I did report instances of leaks to the media to the Office of Professional Responsibility within the department.
And those were leaks to the media about that internal debate?
Yes, among other things.
Now, as we all know, the controversy within the department over this draft letter and the meeting in the Oval Office was also leaked to the press.
Correct.
Was that made the subject matter of an OIG investigation?
I don't know.
Did you report it to the OIG?
Excuse me, I believe he said the Office of Professional Responsibility, not
Oh.
the OIG.
Correct
just
me, sir.
To be clear, earlier I said OPR, which is the Office of Professional Responsibility within the department. You said OIG. I'm not aware
My
of,
mistake, I apologize.
that's fine. I'm not aware of anyone being referred to OPR, or for that matter, OIG, based on the leak about the January 3rd meeting in the Oval Office.
All right. You reported the leak of the debate over the Barr memo of November 9th to OPR.
I reported a number of leaks that I thought were, obviously all leaks are inappropriate, but
But on that particular controversy.
yes, I did. I reported that to OPR.
But you did not regarding the November 3rd meeting?
I did not report that to OPR, no.
Why not?
That was a White House meeting. I was entirely confident that whatever that leak was did not come from the department. It certainly was not the acting attorney general. It certainly was not me. I do not know who did it, but I did not have any reason to believe it came from anyone within the department. And it certainly wasn't in Mr. Clark's best interest, so I didn't think it was him either.
Right. And so you felt it wasn't within the jurisdiction of the department's OPR office?
Correct.
All right, sir. And for the benefit of the committee members that don't know what OPR is, would you please explain?
Office of Professional Responsibility, they look at allegations that department officials have violated their ethical obligations.
Their duties under the rules of professional conduct?
Correct.
And OPR proceedings can be conducted without disclosure of executive privileged information? Public disclosure?
Yes, good afternoon,
They
Stephanie. As
can
you just
conduct
mentioned, around
proceedings,
1:30
really
in the morning,
investigations.
the
They don't
Francis
have
Scott Key
boards such
Bridge
as we
and
have
the
here
Baltimore
today.
Harbor collapsed.
So OPR
The
can do an
Singapore flag
investigation and then
container
report up
ship
to the
named
individual
Dali,
supervisor
struck
if
one
they
of the
believe
support
that they
beams
have
of the
violated
bridge,
ethics
causing
rules.
it to
And
collapse.
then a decision will
We
be made
have
as
heard
to
from
does it get
preliminary
referred to the
reports
state
that
bar.
the ship
Right.
allegedly
And all of
lost
that is under the
propulsion
umbrella
and
of
even issued
executive
a
privilege
mayday
and law
call,
enforcement privilege.
and authorities
No,
then
not
also
necessarily. I
diverted
don't know why that
traffic
would be
from
law
going
enforcement
into the
privilege.
bridge before the
Executive
ship
privilege,
hit the structure and
potentially,
made it
but,
collapse. Let's
you
listen
really-
to what Governor
we
Westmore
think
had to say
in
about
the department as
incident.
executive privileges really being limited to communications with the president,
All right,
perhaps
sir.
other higher level officials, but your routine OPR matter does not involve that.
All right, sir. When Mr. Barr spoke of fraud on a scale that would change the outcome of the election, is he speaking about well, let me ask what you are referring to instead of what he's referring
The
to.
Francis Scott
When
Key
you
Bridge
speak
was
from
built
time
in
to time, as you have in emails and
1977.
so forth,
It was
and in your testimony
1.6
about
miles
fraud
long. It
that
had
would change
4
the
lanes,
outcome
2
of
in
the
each
election.
direction. It was one
Are
of
you talking
3
about the
arteries
national
to cross
election
over the Patapsco
or
River into
individual
Baltimore
state?
City. The other 2
I'm actually
tunnels.
talking about both,
President
and
Biden
sometimes I
earlier spoke
specify it, but
about
if
rebuilding this bridge.
there
Let's
was
listen to what
fraud
he had to say
that
earlier.
impacted the outcome in a particular state, we'd be very concerned about that. We'd be much more concerned. Obviously, it affected the national election, but I think the AG was pretty careful, and I tried to be careful about specifying it was both. It wasn't as if in state X, we think they got the results wrong because of fraud, and we're not going to say anything about it. It was really both. There was no, even the states that were close, like Georgia, which was 12,000 votes, we couldn't confirm fraud on a level that would change the outcome.
And if you had, but there wasn't enough fraud in other states to change the result nationally, would the department have disclosed the fraud that was found in the one state?
Hypothetical,
Well, according
but I think
to
yes,
authorities, as
because I
far
think
as
the
we know,
department
at
would
least
have
8
prosecuted
people
one or
fell
more
onto
individuals
the
for the
water.
fraud.
6 of them part of a construction
Now,
crew that was working on the bridge,
referring
fixing
back to Mr.
potholes.
Clark's
The other
draft
2
letter,
were rescued. One of them remains in critical condition at the hospital. The other
does the
one
word
is in
fraud
contact
appear
with
anywhere in that
authorities.
document?
Let's listen to what Fire
I don't
Chief
believe
James
so.
Wallace
I don't know.
had to
It's
say
a long
about the
document,
rescue
obviously,
efforts
but
still
I
underway.
haven't read it for a while, but I know he uses the word irregularities at the outset.
All right, sir. And then significant concerns.
Yes,
And then he turns into the legal analysis,
yes.
right?
Yeah, I think that's generally right.
So the National Transportation Safety Board
he's
is
talking about a
the
different
agency
subject
in charge leading
than
rescue
the
efforts
fraud
and the
that the
investigation. The
department
Coast Guard,
investigated
of
and
course, is
ruled
also
out,
operating,
isn't it?
and the FBI,
He's
the
talking about a
governor's
broader
office,
issue
Senator Von Hollen
of
have all been
irregularities, fraud.
in the area since early
would
hours
assume
of the
it's a
morning.
subset of
It's
that, but
important that
that's
we
why I
highlight
responded
that as
in
far
my
as we
email
know,
saying
as far
that,
as authorities have shared with the
even if
media,
that is the
there
case,
is no
it's not the
information that
department's role to
indicates a
tell
terrorist attack.
states how
As
to
far as we
conduct
know,
their
only
investigations.
8 people
All right,
fell
sir.
onto the water, but rescue efforts are still underway.
Now,
As we heard from Fire Chief
if
James
the letter
Wallace,
had gone
there have
out
been
to
some
Georgia
vehicles
officials,
identified that might have
even
fallen
according
onto
to
the
its
water
own terms, it would be
the bridge
entirely up to
collapsed.
them
Back to you.
whether they did anything in response, correct?
Yes.
Of course.
In this case, Mr. Donahue, Mr. Clark is charged with attempted dishonesty in preparing and recommending this draft letter. In your experience as a lawyer, have you ever heard of a lawyer being disciplined for attempted dishonesty over a draft document that never left the office?
Objection. No, he's asking for an expert opinion, I think, on an ethical issue.
I'm asking for within his experience as a lawyer.
Yeah, I don't think he's asking for an ethical opinion, but I don't know what the foundation is for the question, but if he knows or doesn't know, he can answer it.
All right, sir.
In 30 years of practice, I thankfully had very little experience with disciplinary proceedings, so I don't recollect any.
All right, sir. And have you ever heard of a bar discipline case for attempted dishonesty in confidential, privileged, pre-decisional discussion drafts or documents?
Again, I don't review the disciplinary opinions that are published on a regular basis, so no.
Did you understand or perceive that Mr. Clark was recommending the department take a different position on election issues in Georgia than you and Mr. Rosen had?
Yes, he was.
Is it dishonest or attempted dishonesty to recommend a change in policy or position merely because the position or policy being recommended is different than the existing policy or position?
Not merely because it's different, but if you're making factual assertions that are incorrect or false, that's obviously a standalone issue.
All right, sir. From your experience as a senior executive in the Department of Justice and a U.S. attorney and so on, would it have a chilling effect on the candor of lawyers in confidential discussions if they had to be afraid of being disbarred for making suggestions that policies or positions be changed?
Objection. Again, he's asking for an opinion, and if it's a hypothetical, it's certainly an incomplete hypothetical.
Well, yeah, I agree. It's an incomplete hypothetical. Why don't you, I know this violates everybody's tenet of cross-examination. Why don't you ask an open-ended question?
Would it have a chilling effect on lawyers' candor in confidential internal deliberations if they had to worry about being disbarred for giving their honest opinion and recommending that a position be changed?
Same objection.
Yeah, I don't think you rephrased the question at all. I think you repeated it or materially, Mr. McDougal.
All right, I'll ask it differently. What effect would it have on lawyers' willingness to be candid in confidential internal deliberations if they face the risk of disbarment for voicing their candid opinions and recommending a change in position or policy?
Same objection, same question.
It's the same question. Yeah. Mr. Donahue, if you can answer the question, answer it.
So I agree that if people in the profession hear that someone's been disbarred for simply proposing a different position legally.
Confidentially.
Yeah, I think that could discourage people from being as candid as they otherwise might be.
And the whole point of the privileges is to encourage candid discussion and advice. Isn't that right?
Objection.
Depends on which
Yeah,
privilege.
I mean, you're now asking him for an expert opinion about law. Okay. If you can ask him about things about his experience, I'll allow it, but asking him to opine about what the point is of a privilege is not really something a witness can be expected to do. So
In your experience as an attorney, how long have you been a lawyer?
32 years.
All right, sir. In your 32 years practicing law, in your experience, have you relied on the confidentiality of your confidential deliberations to candidly express your opinions?
I don't think I've ever thought about it. I just candidly express my opinions, and what happens, happens, but I've never been chilled or not chilled.
And it would be fair to say you were extremely candid in your opinions in the Oval Office on January 3rd on this matter.
Yes.
From what we've previously heard from you, Mr. Donahue, it's fair to say that Mr. Clark had a different opinion about the letter than the rest of the lawyers in the room, correct?
I'm sorry, different about what?
He had a different opinion about the propriety of the letter, the wisdom of the letter,
The letter.
and so on.
Yes, he had a different opinion, yes. But he also was proposing different facts.
Right.
That was the problem.
He had a different opinion of what the facts were from you and
Yes.
Mr. Rosen.
Yes.
And he had a different opinion than you on the significance of the facts.
I don't know about that. I think we just fundamentally disagreed on what the evidence showed. And so we had a different factual starting point. I don't think it was a matter of the significance one way or the other. It was just, we were almost like living in two different worlds.
Right. We've already discussed that facts about irregularities apart from fraud, you did not think they were significant.
I didn't think they
Department
were.
of Justice.
Right. For the department's perspective, yes.
Right. But did it appear to you that Mr. Clark did think they were significant?
He seemed to, but again, it relayed that he didn't understand the department's role then. And that's why we explained it to him repeatedly.
In your view, the facts regarding irregularities other than fraud were not significant in light of the department's role as you saw it. He did not agree with that framing. Was that fair to say?
I would say that they were not part of the department's role. It wasn't a matter of whether I was opining as to whether they were significant or not. That was for others to decide. He clearly, based on what he perceived to be frauds, plus what he perceived to be irregularities, was pushing for the department to do something that the department does not have any role or responsibility in.
And the statement that the department has no role is a policy judgment by the department's leadership. Is that not?
No, I don't think so. I think that's constitutionally based. It's the states that run the elections. It's not for the Justice Department. It's not for the executive branch. It's not for the federal government to dictate to the states the procedures for doing that.
The electors clause of the Constitution delegates to legislatures.
Right.
The creation of rules for presidential elections.
And all of the legislatures have set forth those rules and statutes.
And that those rules therefore have independent federal constitutional status, don't they?
They are referred to in the Constitution. The delegation is made clear to the state legislatures.
And there was an issue surrounding the 2020 election that there were non-legislative changes in the rules for electing the president in a number of states.
In some states, yes.
Right. And under Bush v. Gore, that is a federal constitutional issue.
Objection.
Yeah, that really does ask him for a legal opinion.
He's indicated that there's no Justice Department role under the Constitution in the administration of state elections. And the question goes directly to that statement.
Okay. His opinion, excuse me, his opinion on it isn't how this is going to get decided, Mr. McDougall. You can argue that he was mistaken in your brief. You can cite all the case law and we can analyze the law. But asking him what his opinion is of the operation of the election, the operation of the electors clause and the application of Bush v. Gore to this case isn't something he's in a position to testify about. It's,
he's already testified about it by saying there's no Department of Justice role under the Constitution.
He's provided you with his understanding. If you believe he's mistaken, you can write your brief and argue he's mistaken about it. But I don't understand.
He's testifying, and I'm have to answer it in a brief. I can't cross-examine him about the testimony he's given on what the Constitution does or doesn't require.
Mr. McDougall, the initial question about it, he's told you what he understands the role to be. Okay, whether his understanding is correct or not is a legal question. Are you going to take him through 100 cases? We could spend all day doing that.
I will move on, Mr. Hirsch.
Thank you.
You and Mr. Clark had a different opinion about what, if anything, ought to be done in the situation that was in front of you. Is that fair?
Yes.
And all of your differences with Mr. Clark were sort of a combination of fact, opinion, law, policy, and judgment. Is that fair?
No, some of them are just factual disputes.
Okay. Well, you thought the letter was a terrible idea. He thought it was a good idea.
Basically, yes.
And that judgment on your part that it was a bad idea was involved prudential matters beyond just law and fact. Correct?
It did involve prudential matters, but it was also focused on the facts. He was making affirmative claims about what the department had found. And that was not the department.
He was proposing that the department take that position.
He was purporting to speak on behalf of the department about conclusions that it had reached, and those conclusions were not the conclusions we had actually reached.
But my question is, this is a proposed position,
Yes,
and it never left the department in the end
it did not because of the meetings,
because of the president,
ultimately the January 3rd meeting, right?
because of the president's decision.
Correct, to overrule his request, yes.
And in the January 3rd meeting, you argued that Mr. Clark was not qualified to be acting attorney general.
Correct,
And at least part of that was because he'd never prosecuted a criminal case.
correct.
Did William Barr ever prosecute a criminal case?
I don't believe so.
How about Jeff Rosen?
I don't believe so.
When the president asked you the first time about making Clark attorney general, when he floated it to you and Mr. Rosen, I believe your answer was that he should have the leadership team that he wanted.
Yes,
And whether it was wise or not, under the circumstances, the president had the authority to fire Mr. Rosen and appoint Mr. Clark if he chose to do so.
100%.
And that decision lies with the president and not the DC bar, correct?
Correct.
Or Mr. Fox.
It's only with the president.
Laying to one side, for purposes of my question, whether you agreed with the letter or thought it was a good idea. If the letter had been approved and sent as a statement of DOJ's position on the matters that it addressed, that would in fact be DOJ's position on those matters, wouldn't it?
If it had been sent, the department would have been misleading the legislature. So obviously that would be problematic. I can't say that it's impossible, because if the attorney general, whoever that may be, decide to send that letter would go out.
And my question was, if the attorney general sent the letter out, then the letter would be the position of the Department of Justice, correct?
Yes, but it wouldn't be true.
Well, as to the matters that represent policy choices by the department, it would be the policy choice of the then attorney general who decided to send it out. Isn't that right?
Right, but the attorney general, whoever they may be, can't choose to lie. You simply can't tell people in a letter or otherwise the opposite of what the department has actually concluded.
Okay. Did you know of a U.S. attorney in the Eastern District of Pennsylvania named McSwain?
Yes,
And was Mr. McSwain directed to cease investigating election matters by Attorney General Barr.
Objection, this is out, not only outside the scope, it doesn't have anything to do with Georgia.
I'm sorry, I didn't hear the last part of your.
It doesn't have anything to do with Georgia. So they're asking if something happened in Pennsylvania, which is outside of the scope of direct, and which doesn't have anything to do with the issues before us.
Well, there was.
Hold on one second, Mr. McDougall. I don't know where this is going, and I don't know whether the question is objectionable. I'll allow it if it goes in a direction that,
Okay.
wastes time, then we'll get to
Okay.
it. But so far as the questions go, I
The
don't know.
chair will recall, we had quite a bit of testimony on direct about issues in Pennsylvania.
Mr. McDougall, I overruled the objection. There's a lawyer rule when you're hitting something. Okay.
Okay, I apologize. Can you remember the question?
I do. And to sort of give you a complete answer is obviously there were communications between AG Barr and Bill McSwain that I was not part of. But I was part of a broader discussion, both with the AG and with U.S. Attorney McSwain. My recollection is that at no point was Mr. McSwain told to not pursue any investigations.
To your knowledge, was he directed to turn his investigations or investigative leads over to the state attorney general?
No, he was not.
You're familiar with a letter, or you've heard of a letter that he wrote to President Trump?
I have read that letter, yes.
Yeah, and so you don't agree with the statements made in there about these topics?
Correct. And I talked to Mr. McSwain after that letter became public.
Okay. And do you know of a Mr. Tony Schaefer?
I do recall that name, yes.
And that he had some connection with the truck driver, the postal service truck driver on the Long Island to Pennsylvania matter you mentioned earlier?
He did have connections with one of the allegations. I can't recall if it was the truck driver.
And do you recollect that Mr. Barr phoned Mr. Schaefer and told him essentially to back off?
Now that you say that, I think that's an individual I spoke to who said that the attorney general had yelled at him. Yes.
But you were not part of that phone call?
No.
Did Mr. Barr tell you about that phone call?
I don't know if he told me first or Mr. Schaefer called me. I think Mr. Schaefer called me and said, I'm calling you because the attorney general just yelled at me. It was a strange conversation. And then I spoke to the attorney general afterward and he said, yeah.
Said he had yelled at him?
He had yelled at him, yeah.
Did you get many phone calls from people complaining the attorney general had yelled at him?
No, most people didn't complain.
Okay.
We considered it a job perk.
Did you know of a U.S. attorney named Larry Keefe, I think in the Northern District of Florida?
Yes, I do, Larry.
Did Mr. Keefe have any investigative leads on the election that you're aware of?
I don't recall specifically, but he may have.
And do you recollect whether he was directed to abandon those leads?
As I sit here now, I don't remember ever dealing with Larry Keefe about any election issues at that time.
Okay.
I certainly didn't direct him to not pursue things.
You did not?
I certainly didn't.
Okay. All right, sir. Now, the president asked you about absentee ballot signatures in Fulton County and a phone call. I think you said it was on January the 2nd. Maybe I've got my date wrong, but it came up in a phone call. You testified earlier.
There were two phone calls. One was on December 28th in the morning. I don't remember what it was, but he was recounting something he had told us the night before.
Right.
January 3rd, there was a phone call at about 11 p.m. That had to do with a truck in
Right.
Georgia.
And this would have been January 2nd, and it was the suggestion was made that you, Rich Donahue, go down to Fulton County and look into absentee ballot signatures.
Oh, that call was December 27th.
Okay, I
Yeah.
apologize for getting the date wrong. And you testified earlier that absentee ballot signature verification was not something that DOJ would be looking into.
generally, if it rose to the level of criminal conduct, that could draw attention and might warrant an investigation, but if it is sort of a lower level issue about how precise the signature matches are, then that's unlikely something the department would get involved in.
So as a result of that conversation on the 27th, did you do or cause anything to be done to look into the issue of absentee ballot signature verification in Fulton County?
Yeah, I think that the U.S. Attorney's Office in the Northern District was looking at that, as well as the other issues that came out of Atlanta.
And did you get a report then that there was nothing to it, that there wasn't anything to this absentee ballot signature verification question in Fulton County?
Yeah, as I sit here now, I don't remember the answer to that, but I certainly didn't get anything back saying that there was cause for concern.
All right. And you didn't go down there yourself?
I did not. I think the chief of staff went, by which I mean the president's chief of staff, not anyone in the department.
I don't object to using these in argument, but if we're going to confront a witness with something, it ought to be something that's in evidence
Well,
and not a poster board.
I believe this is an
This
enlargement.
exhibit is in evidence.
I'm sorry, is this-
And
Yeah,
yeah,
this
this is disciplinary exhibit 12.
Well,
And it's just a blow up. So if he wants to do it that way,
All right,
that's
that's-
fine.
it's a rare moment of agreement between myself and Mr. Fox.
Okay. We'll mark the moment in history.
Are you able to see that?
I can see it. It looks like this is the same as
It's the
tab 12.
number 12.
Yes.
You'd rather look at it on your book.
That's it.
Okay.
I can see it.
All right, great.
I got it in front of me.
I'll take this down. No, probably something the committee can see it. So this is an email chain, starts with Meadows, and then it's you and Mr. Rosen, correct?
Yes.
And on January 2nd, Mr. Meadows is asking Mr. Rosen to have Jeff Clark check into signature match anomalies in Fulton County, correct?
Correct.
And if it's coming from Mr. Meadows, that means it's a request from the president, doesn't it?
Yes, I think that's fair.
All right. And Mr. Rosen forwarded this to you. And he says, can you believe this? I'm not going to respond to message below.
Yes.
And then you replied, at least it's a little bit better than the last one. Right?
Correct.
And I believe your view of it was that having Mr. Clark to look into that topic just wasn't the way the department operated.
Having Mr. Clark look into any criminal investigations was not the way the department was going to operate because he was the AAG of the civil division.
Or are you saying this was a criminal investigation on absentee ballot verification?
Yes. Otherwise, we'd had no role in it.
All right. So what was the outcome of your criminal investigation of the absentee ballots?
Again, I don't specifically, as I sit here now, 3 years later, recollect, but I certainly didn't get anything back saying that was a problem.
Well, if that was the case, if it was a criminal investigation within the ambit of the Justice Department, why did Mr. Rosen say he wasn't going to do anything about it?
No, he says, I'm not going to respond, which is the chief of staff telling him to use Jeff Clark. And what he was clearly communicating to me in the context of larger conversations that we were having was, we're not sending Jeff Clark anywhere.
All right.
Jeff Clark is not going to go do a criminal investigation related to election when he's never done a criminal investigation.
All right. Now, you mentioned the ODNI briefing that Mr. Clark was allowed to have.
Right.
Mr. Clark's cover email on the 28th also asked to look at the investigative files on the criminal investigations or inquiries that had been made. And he was not allowed to see those, was he?
No, he was invited to call BJ Pack and get whatever information he needed, and he just didn't do it.
Well, my question was he allowed to review the investigative files like he asked?
He was told to call the U.S. attorney and he would understand the investigations, whether that was access to the file. I don't think we got into that level of detail. But since he had concerns specifically about Fulton County, Jeff Rosen's response was just call BJ and you'll get all your questions answered. And that's how it was left. And then when he came back a couple of days later, my second question was, did you call BJ? And he said no.
All right, so I'll try one more time. Was he granted access to the investigative files, yes or no?
Objection, this was just asked and answered.
It has not yet been answered, Mr. Hirsch.
He was never denied access to the files.
Was he ever granted access to the files?
I can't answer that question that way. He was told, go call the U.S. attorney. He didn't do it. So now we never got to a point. He never even asked for access to the files in terms of saying, I need to see everything that happened in Fulton County. He was invited to call the U.S. attorney. He chose not to do it. He didn't explain why.
And is calling the U.S. attorney in Atlanta the same thing as getting access to investigative files?
Calling the U.S. attorney is the best route to find out what happened in the investigation.
Is it the same as getting access to investigative files?
I would think, had he made the call, he would have been given access to the files. That's the appropriate person to whom to make that request, the person whose office ran the investigation.
Are you aware that Mr. Pack testified that he didn't look into absentee ballot signature verification?
I have not reviewed Mr. Pack's testimony.
And so in the end, you don't know one way or the other whether the department did anything to look into absentee ballot signature verification in Fulton County. Is that fair?
As I sit here now, 3 years later, I don't specifically recall that, and Mr. Pack would be in a better position to know about Fulton County.
I believe on direct, you testified that absentee ballot signature verification was a process matter that was outside the scope of what the department would look into. But now you've said it was a criminal matter. So which was it?
It might be. It depends on what you're seeing. So when you have a signature match, there is a certain tolerance level. And the tolerance level is actually worse now than it was in days past, because in days past, we used to put a pen on paper and sign it, and someone would look at it to see if that's the same signature. But because we now sign on tablets and other electronic devices, we all know how terrible those signatures are, right? And so my understanding is that in most states, they have an automated signature match, and that you can adjust the tolerance levels for what would be a confirm or a reject. Those issues may well be simply process issues. If it rises to the level that there's some indication that there's a mass number of fraudulent signatures and hence fraudulent ballots, then that, of course, is something the department would be interested in. But that was never brought to our attention that there was actual evidence of that. I know there were challenges. I know there was civil litigation talking about the tolerance that was being used in different jurisdictions to judge the absentee ballot signatures. That was not something the department was involved in.
All right, sir, do you see on your screen, Mr. Barnes, November 9 memo?
Yes.
So do we have an exhibit number for this?
Yeah.
This is 559. I apologize. And it would be in, I can bring this to the binder.
I can see the screen fine.
Very
That's
good.
fine.
Very good. Now, the subject line is post-voting election irregularity inquiries.
Yes,
And the word irregularity appears quite often in this document, does it not?
it may, yeah. If that's the title, sure.
Right? And you see, I'm going through
Mhm.
with the find command, highlighting all the times that it talks about irregularity. But it doesn't really talk much about fraud, does it?
Again, I always perceive fraud to be a subset of irregularities, but I don't know if it says anything about fraud specifically.
Well, did the Attorney General's memo articulate the position that we have discussed that the department had no role for irregularities apart from fraud?
And civil rights.
Pardon?
And civil rights,
I-
yes.
I
Right.
keep failing to include that. I apologize. Did he make that clear?
Did he make it clear the department had no role?
In irregularities apart from criminal and civil rights.
I haven't read this memo in quite a while, but given the fact that he's using the term irregularity in the title, I would assume he uses that throughout. And it's probably broader than I would have drafted, but
his testimony to J6 committee and his press statements were they only looked at fraud and not irregularities. We talked about that before, didn't we?
you asked some questions previously about that. Yeah.
Yeah, and that was the answer. That his position and your position and Rosen's position was that the department would not be looking into irregularities apart from criminal matters and civil rights matters.
Well, again, irregularities is not really a term of art, so people may perceive it differently. But to me, fraud was a subsection of irregularities. There are irregularities that could initially not look like they are criminal, and upon further investigation, turn out to be criminal. So that's possible. And then you've got civil rights issues, whether people have access to the ballot, et cetera. So it's certainly a broader term, but it's not a term, to my knowledge and experience, that's normally used within the department. So it might be meaning different things to different people. But the title of his memo is Post-Voting Election Irregularities Inquiries.
All right, sir. I'm going to show you exhibit
Excuse me, Mr.
R61.
McDougall, do you want to offer exhibit 559?
Thank you, Judge. I do.
Is there any objection to it?
No.
Okay. All right.
And this impeaches the witness's testimony about a couple of things. In the beginning, on direct, his testimony was that absentee ballot signature verification was a process and rule matter that the department did not go into. Now on cross, he said it's a potentially criminal matter, and he's indicated they did look into it, but he doesn't know what they did or who did it. And so the questions that I'm asking now go to whether it should have been investigated. They took the position with the president that it wasn't going to be investigated, and they didn't investigate it. And because they didn't investigate it, we got a gigantic breach of election law in Georgia that the Justice Department was completely blind to because they didn't look into it.
Mr. McDougall, you're going a little beyond my inquiry. I'm trying to understand the facts. You can make your closing argument and the significance of this separately, okay? I'm trying to understand what the witness knows. You can ask him, were you aware of this? You can ask him whether it was investigated, okay? You can ask him, that. You're asking him about a specific number and you haven't established that was a number anybody knew about. And that's where I'm having difficulty.
Okay. Mr. Donahue, were you aware of these numbers that I've shown you?
So I've never seen these numbers before you put them on screen.
All right. And if these numbers are true, do you think maybe y'all should have done more on absentee ballot signature verification?
Objection.
I'll allow the witness to answer.
If pursuant to the proffer you just made, the fact is that they did no signature verification, that's a process issue. The campaign can bring a lawsuit based on that. And I think they probably did. It's not a department issue. It only becomes a department issue when it reaches the level that there is evidence to suggest criminal conduct. So no, these numbers don't tell me that.
So
Nor does the absence. And how could they possibly reject anything if they did no signature matching? You're saying they rejected 6 based on what?
it's Fulton County.
That's not a very good answer, sir.
If you knew Fulton County, it would be a great answer.
Excuse me, Mr. McDougal, you're now. Mr. McDougal, please ask questions.
That's all the questions I have for Mr. Donahue.
All right, thank you. Any redirect?
No questions.
Does the panel have any questions? All right, I don't have any questions, Mr. Donahue. Thank you very much for your time. Appreciate it.
Thank you.
Mr. Chair, our next witness, Philbin, testified remotely. I'm not sure if he's in waiting for not.
Can you speak in the mic? I didn't hear you. Sorry.
The next witness is Mr. Philbin. And question is whether he's in the waiting room.
He is.
Okay,
Mr. Hirsch, I would like to lodge an objection under the confrontation clause to Mr. Philbin testifying remotely in a proceeding that's quasi-criminal in which Mr. Clark faces the loss of his livelihood. Mr. Fox pushed and pushed and pushed for this hearing to happen today. We asked for it to be continued, and the panel knows why. And Mr. Clark is sitting there with all the conditions that supported that motion for continuance. And they don't even have the witness here to testify against him.
two things, Mr. McDougal. First of all, do not allude to that proceeding, okay? You're revealing information by what you're describing, and I think in fairness, it ought to be kept confidential, and that's under seal. Secondly, I'm overruling your objection.
All right, letting the witness in now.
Good afternoon, Mr. Philbin.
Good afternoon.
My name is Merrill Hirsch. I'm the chair of this hearing committee. Would you like to be sworn or affirm?
I'll swear.
Okay, could you please raise your right hand?
And I'm sorry, it's not showing my video here, so I'm not sure what picture you're seeing.
Okay, I'm just seeing you and the ceiling, but I am seeing you. Okay. Do you solemnly swear that the testimony you're going to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Could you please state your full name for the record?
Patrick Francis Philbin.
All right. Thank you, Mr. Philbin. Mr. Burrell, please proceed.
Thank you. Good afternoon, Mr. Philbin. Can you hear me?
Yes.
Okay. Mr. Philbin, what is your profession?
I'm an attorney.
And are you a member of the DC Bar?
I am.
Do you currently practice with a firm?
Yes.
Which firm do you practice with?
Toradon Law, PLLC.
And where is that firm located?
The original office is in Virginia, and we have an office now in DC at 1155 F Street.
How long have you been with that firm?
With that firm, only since January of this year.
Where did you work prior to your current firm?
I was a partner at Ellis George Cipollone O'Brien, which was, it's an LA-based firm, but we also had the office here in DC.
How long were you there?
From October of 2021 until January of 24, this January.
Mr. Philbin, did you previously work in the Trump administration?
Yes.
Where did you work in the administration?
I worked in the White House. I was a deputy White House counsel.
And when did you start that position?
December 10th, 2018.
And when did you leave that position?
January 20th, 2021.
Just generally speaking, what were your duties as Deputy White House Counsel?
Providing legal advice to the executive office of the president. So any legal issues that would come up on important policy questions, important initiatives for the administration that needed some sort of legal check at the White House, or coordinating legal strategy among departments and agencies. That was my responsibility.
Okay. Where did you work prior to joining the Trump administration?
I was a partner at Kirkland and Ellis.
And how long were you at Kirkland and Ellis?
From May of 2006 until I left in December of 2018. And then before that, I was at the Department of Justice and had previously been at Kirkland. So I had 2 stints at Kirkland.
Okay, I want to break that down a bit. First of all, when you say you work at Kirkland, I think that Kirkland has several offices. Which office were you in?
In the Washington, D.C. office.
And was that during both stints at Kirkland?
Yes.
So when you were at Kirkland prior to the Trump administration, I think you said May 2006 to December 2018. What was your practice like there?
General commercial litigation, mostly sort of what's called issues and appeals in some firms. I don't take a lot of depositions and do that sort of trial work, but prepare legal briefs, argue dispositive motions, argue appeals, work on tough legal questions for clients, that sort of thing.
Okay. And you said prior, I guess, to the second stint in Kirkland, and I apologize, I'm kind of going backwards in time. You were at the Department of Justice, is that right?
Yes.
What administration was that during?
The George W. Bush administration.
And what was your role at the Department of Justice in the Bush administration?
I started in September 2001 as a Deputy Assistant Attorney General in the Office of Legal Counsel, and I was there until June of 2003 when I became an Associate Deputy Attorney General in the Deputy's Office. And I was there until November 2005.
And then prior to the Department of Justice, I think you said you were at Kirkland the first time around. What was the time frame of that?
From 1995 through August of 2001.
Okay. Mr. Philbin, do you know Jeffrey Clark?
Yes.
How do you know Mr. Clark?
Well, I think we started almost at the same time at Kirkland in 1995, or he might have started in 1996, but back to that time frame.
Okay. And when you and Mr. Clark were at Kirkland together in the mid-90s, do you recall what Mr. Clark's areas of practice were?
I think somewhat similar to mine. He did a lot of briefing and appeals, and I'm not sure at what point, but started to specialize, but doing a lot of regulatory stuff, and then particularly challenges to EPA regulations, so environmental regulatory challenges.
Mr. Philbin, what, if anything, do you know about whether Mr. Clark has prior government service before the Trump administration?
I'm pretty sure that he was in the Bush administration at DOJ in ENRD, the Environment and Natural Resources Division at DOJ.
Did you work with Mr. Clark while the two of you were at the Department of Justice during the Bush administration?
I might have to some extent, but I don't really remember specifically, because I ended up largely doing anti-terrorism things after 9/11. Almost all of my work was on war on terror issues.
Do you know what Mr. Clark did after the end of the Bush administration?
He was back at Kirkland. I don't know the exact timing or whether there was a gap or something, but he was back at Kirkland.
And do you know what Mr. Clark was doing at Kirkland following his stint at DOJ?
I believe similar things, because my assumption to my understanding was that because of the role he had at the Environment and Natural Resources Division, he was, even more specialized and better placed to be an environmental regulatory lawyer. So he was in demand for that sort of work.
Mr. Philbin, I want to direct your attention now to the end of the Trump administration, specifically between December 14, 2020, which is when Attorney General Barr announced his resignation, and January 3, 2021. During this timeframe, did Jeffrey Clark come to your attention in connection with the 2020 presidential election?
Yes.
How so?
At some point post-election, and I don't remember the exact time, the exact timeline's a little bit fuzzy, but at some point in that December timeframe, the idea was raised to have someone at the Department of Justice, in addition to the people who were looking at various potential claims of voting irregularities or voter fraud, that someone should be also looking and taking another look at those things. And I believe, and I don't know the details, but that the idea came that Jeff Clark's name came from the White House as someone who could be helpful in taking a hard look at things, kicking the tires, and making sure that the idea coming from the White House was to make sure that there was a hard look being taken and things that were actually potentially questionable weren't being overlooked.
And so how is it that all of what you just testified to actually came to your attention? Did someone tell you this?
I believe so. And again, I'm not sure of the exact timeline or even exactly who told me first. I know that at one point I had a conversation with the acting attorney general, Jeff Rosen, about it. I'm sure that I had conversations with the White House counsel, Pat Cipollone, about it. But exactly who told me first and how that developed, I don't remember the details.
Do you recall what Mr. Rosen told you about Jeff Clark?
Well, I think we had a conversation in which he was explaining that, and I'm using the term White House because I don't remember specific names, this being, placed as a particular person communicating, but that the White House was pressuring the acting attorney general to have someone look at things, and that Jeff Clark's name had come up. And I had a conversation with Jeff Rosen saying, well, that seems fine. If there are, in order for the president to feel comfortable that things were being looked at, if another person in DOJ could take a look at things, as long as, Jeff Rosen is agreeing with this and sort of maintaining some control over it, that's fine. Have Jeff Clark look at it. Because I thought Jeff is a good lawyer.
What was your understanding of why Mr. Clark's name came up with regard to looking at the 2020 election?
I think I learned afterwards. I don't think I knew this at the time, or I might have known it somewhat afterwards, that I think it's a Representative Scott, that there was a congressman who was telling the president that Jeff Clark was a good guy who is trustworthy and should be trusted to take a hard look at things.
And after it came to your attention that Mr. Clark had been floated to look at the issues in the election, did you speak with Mr. Clark?
I did at some point. And again, the timeline is fuzzy, but I believe I had one, perhaps more than one, but I think one conversation with him before Sunday, January 3rd.
And just to back up for a minute, I believe you referenced Scott. You were talking about Representative Scott Perry, is that right?
Yes.
And so going to the conversation with Mr. Clark, how did that conversation occur?
I don't remember all the details of exactly who spoke to whom and what, but I think I had had a conversation with Jeff Rosen. Jeff Rosen, I think, had some concerns that Jeff Clark was perhaps pursuing things that weren't worth pursuing, that, you know, there was no there there. And I had a conversation with Jeff Clark just to find out, hey, what's going on? What are you looking at? What are you finding? You know, how are things going in this role as taking a second look at things?
What specifically did Mr. Clark say during this call?
I don't remember the specifics of the call. I think that, I believe that in that call, we talked about some of the various theories of fraud that were floating around at that time. And one in particular that had to do with a person who, I forget, had some connection to the CIA, either had been a CIA informant or the CIA knew about this person, and this person was in Italy, and he knew how, he claimed to know how there was some mechanism to affect the voting machines, and there was, I don't know, the idea was someone should actually interview this guy because he knew things about a plot to alter the votes on voting machines.
Did Mr. Clark tell you how he thought someone should, I guess, work out the interview with this person in Italy?
I don't think so from Jeff Clark. I think that at some point I heard, you know, there was an idea that I think this person was in prison, but could be released from prison, like released to U.S. military custody. Somebody wanted him to go to the naval base at Naples, I believe, or else have someone from the naval base at Naples go talk to him in jail. But those are just things I remember that were swirling around. I don't remember Jeff Clark specifically saying that.
Did Mr. Clark say anything about the particular actions he had been taking to investigate allegations of fraud?
I think he did, but I don't remember very many details. I know that, you know, he mentioned in connection with this Italy thing, he said he had spoken to some people in the intelligence community, and he thought that maybe there was something there that actually should be, you know, that there should be some inquiry. But exactly what other steps he was taking other than talking to people at DOJ, I'm not sure. If he and then went and talked to other people outside DOJ, I don't know. Or he might have told me at the time, but I don't remember the details.
What was your reaction to what Mr. Clark told you on this phone call?
Well, I thought on that phone call that some of these ideas were not plausible. That, I mean, the Italy thing I had heard of and discussed in other settings, and I thought it was not credible and not anything to pursue. I don't remember in that phone call at that time if we discussed particular other things, but the sort of things that had been raised as potential electoral fraud at that point, because I was talking to Rich Donahue and to Jeff Rosen to find out what they were finding out and what DOJ's, you know, investigations were showing. I thought there was sort of day by day a steady change of things that were raised that maybe sounded like, oh, somebody should look into that, then being debunked. Like there were more votes cast in Pennsylvania than there were people on the voters' rolls. And then I believe that turned out that that was not correct because someone was looking at the wrong year for the voter rolls. And, you know, so, but whether I had a specific reaction to things that Jeff said on that call that I thought were not credible other than the Italy thing, I don't remember, because I don't remember specifically which theories we discussed.
Why did you find the Italy allegation not credible?
Well, it was just, it was too complicated to be plausible that and the guy sounded like it just sounded incredible. The guy sounded like a fabulist, and the idea apparently was that, you know, smart thermostats that were connected to the internet somehow were part of the mechanism for tapping into the voting machines to control things. And it just didn't sound like something credible to me.
I think you said a moment ago that you had been in contact with both Mr. Rosen and Mr. Donahue about the department's work regarding the election. How often were you in contact with the two of them, or individually?
I don't know, probably in the week between the Christmas and New Year's there, probably at least a couple times with Jeff Rosen. And maybe once with Rich Donahue. It could have been more, but I don't know.
After this first phone call with Mr. Clark, did there come a time that you spoke with Mr. Clark again?
Yes.
Do you recall when that was?
Well, I'm not sure if we had a second phone call before January 3rd or not, but I know that, and then I believe I spoke to him during the day on Sunday, January 3rd. I suppose it's possible that that call that I'm thinking of was the day before on Saturday, but I believe it was on Sunday around late morning or midday.
Okay. So what prompted you to speak with Mr. Clark on, I think you said Sunday the 3rd?
Yes.
What prompted you to speak with him?
Well, an idea had been raised some time before, at least, I would say at least a week before. There was a concept swirling around that perhaps Jeff Clark would be made the acting attorney general to replace Jeff Rosen, because Jeff Clark would go to further lengths to pursue some of these ideas about voter fraud. And my understanding was that there was a meeting either on December 31st or on January 1st. And I understood this from Pat Cipollone, that there was a meeting that kind of put that to bed, that ended that idea. That was finished. The president was not, he understood that was not viable, it was not going to happen, and that had been put to bed. But then on Saturday, the 2nd, the idea was revived, and in conversations with Pat Cipollone and with Jeff Rosen, I think on Saturday and then again on Sunday morning, we concluded that I should call Jeff Clark, because I had known him for a long time. I knew him at Kirkland, and to try to find out exactly what Jeff Clark was thinking, and to try to persuade him that moving forward with any idea of him becoming acting attorney general would not be a good idea.
I think you said that the concept or the idea of Mr. Clark becoming acting attorney general had resurfaced. How did you find out about that?
I think from a conversation with Pat Cipollone.
And when you called Mr. Clark, I guess, to be clear, what was the purpose of you calling Mr. Clark? What did you call?
I think at that point on Sunday, January 3rd, there was the idea that the president was perhaps going to move forward to make him acting attorney general. And the purpose of my call was, one, to find out a little bit of background about what Jeff knew about this and what was going on, but primarily to try to talk him out of it, to explain to him that that would not be a good idea.
What did Mr. Clark tell you about the idea of him becoming acting attorney general?
Well, we talked about it for quite a while, and I think Jeff's view was that there was a real crisis in the country, and that he was being given an opportunity to do something about it, where he thought that something improper was happening, and that he had struggled with the decision and thought about it a lot, but he thought that he essentially had a duty where there was something that he thought was wrong going on to take the opportunity being offered to step in and do something about it.
What did you say to Mr. Clark about the idea of him becoming acting attorney general?
Well, I tried to explain to him that it was a bad idea, and for multiple reasons. I think that what we talked through, we talked about some of the theories of fraud that were around, and I explained how I thought they had been debunked and that there wasn't really any there. I explained to Jeff that if the president made him acting attorney general, that people at DOJ would probably resign, that there's going to be just a massive wave of resignations, and people aren't going to be willing to follow him to pursue these theories of fraud that, you know, the people already looking at it from DOJ had debunked. That he'd really be tanking his future career, because this was something that it was not going to succeed. And, you know, it would be starting down a path toward assured failure, because it was not going to be possible to succeed, in part because people at DOJ would resign. And that if by some chance, if by some miracle somehow it worked and he did something and found a way and the president stayed in the White House past January 20th, I said there'd be riots in every major city in the country. And it was not an outcome that the country would accept.
Okay, let's take some of that in more minute detail. You said that you and Mr. Clark talked about some of the theories of fraud. What theories of fraud did you talk about on this January 3rd phone call?
You know, I don't really remember specifically, and it could have been in this call rather than the other that we talked about, the Italy. I think it was the earlier call. We probably talked about the Pennsylvania thing, perhaps something about Georgia, but I don't remember details.
And you said that you had told Mr. Clark that the theories that he was espousing had been debunked. Where were you getting your information to support that?
From Rich Donahue and Jeff Rosen.
Okay. Were you investigating any of the various allegations in the 2020 election as part of your role as Deputy White House Counsel?
Well, not separately investigating, looking into them only to the extent of talking to DOJ, to Rich Donahue and to Jeff Rosen about what DOJ was finding.
And why were you doing that?
Well, because these ideas would swirl around and people would come to the president and provide him bad information and start people down a road of thinking things that were not accurate. And so it was important, because I would get called into meetings that were not about the election, but then at the end of the meeting, there'd be some talk that swirled back, you know, to things about the election. And it was important, I thought, in my role, to have information to be able to respond to things, because if the president has been told one thing and he's got this information that he thinks is good information, when he brings it up, it's very important for other people to be able to give the president accurate information and explain how that something like that is not true.
What did you think about whether any of the allegations that Mr. Clark had discussed with you warranted further investigation?
Well, I didn't think any of them warranted the proposal on the table, which was Jeff Clark becoming acting attorney general, throwing Jeff Rosen out. And, you know, I'm not sure at that point if we were specifically talking about the draft letter to Georgia, but I didn't think that anything warranted some kind of definitive action to try to change the outcome of the election. Whether there was anything left that somebody should look at some more, I don't know. I don't remember that specifically.
And why did you think that the idea of Mr. Clark becoming acting attorney general wasn't warranted?
Because there wasn't anything that had so far been shown that suggested fraud that could have changed the outcome of the election, and that was not being pursued. It's not as if there was a big smoking gun problem there and everyone was trying to turn a blind eye to it. So the only way to solve that situation was to have someone else come in. That was just not the situation we were facing.
Earlier, you said that I believe you said you told Mr. Clark that if he became acting attorney general, something to the effect that people at the Department of Justice would resign. What were you basing that statement on?
Well, I actually had experience in the Bush administration with a situation where the White House wanted to pursue a policy related to a warrantless wiretapping program that if they had pursued it, people at the Department of Justice had determined that they would resign. There was a large wave of people who would resign. And I thought that this kind of thing was similar. And I spoke to Jeff Rosen on January 3rd, suggesting to him that he should let people know, the assistant attorneys general, what was going on, and start determining, whether people would stay or resign. Because one of the things, and this is all public now, this has been made public for years, that was very important and persuasive to President George W. Bush, was hearing that there were potentially going to be a lot of resignations at the Department of Justice. And we thought it was important to know and to be able to inform the president here that if he pursued this course of action, there would be a lot of resignations at the Department of Justice.
What did Mr. Clark say to you regarding the idea that people at the Department of Justice would resign if he were made acting attorney general?
I think he disputed that. He said that, to the best of my recollection, which is hazy on this, that no, he thought there were people who would stick with him, who would be loyal. And he thought that there would be enough people at DOJ for him to be successful.
You said that you also told Mr. Clark on this call that you thought that the path forward was assured failure. I think you said partly because of the resignations that might occur at the department, but were there other reasons why you felt like the path forward, being him appointed acting attorney general, why you thought that would be assured failure?
Well, I didn't see a viable path to actually changing the vote in the Electoral College. And again, I'm really hazy now. I don't remember, one time these things were in my head, but exactly what the proposal was for how it was going to change and all the things that would have to fall in line for that to work, I just thought it was not a feasible plan to come to fruition.
What did Mr. Clark say in response to you telling him that you thought there'd be riots in every major city if President Trump stayed beyond?
Respond to relevance and prejudice outweigh probative value and move forward.
Objection overruled.
Would you like me to repeat the question, Mr. Philbin?
Yes, please.
What did Mr. Clark say in response to you telling him?
May we approach to discuss that, Mr. Coach? I know where this is going, the chairman does not, and I think if I have the opportunity to approach and explain the basis of my election, it might make a difference.
Mr. Hirsch, it's Mr. Clark's own statements.
Yeah, that's why I overruled the objection. It's hard to imagine that his own statement would be excluded, but I'll give you the opportunity. We need to turn the mics off.
Do you want me to shut off the stream?
Yes, why don't you shut off the stream, but okay, I guess there's no one in the room Objection overruled.
Would you like me to repeat the question, Mr. Philbin?
Yes, please.
What did Mr. Clark say in response to you telling him?
May we approach to discuss that, Mr. Coach? I know where this is going, the chairman does not, and I think if I have the opportunity to approach and explain the basis of my action, it might make a difference.
I mean,
Okay.
Mr. Hirsch, it's Mr. Clark's own statements.
Yeah, that's why I overruled the objection. It's hard to imagine that his own statement would be excluded, but I'll give you the opportunity. We need to turn the mics off.
Do you want me to shut off the stream?
Yes, why don't you shut off the stream, okay, is there, I guess there's no one in the room
answer the question. Do you want to restate it?
Sure, I'll re-ask the question. So, Mr. Philbin, what did Mr. Clark say in response to you telling him on this January 3rd phone call that you thought there'd be riots in every major city if President Trump stayed in office after January 20?
He said, well, Pat, that's what the Insurrection Act is for.
And what did you understand Mr. Clark to mean by this?
He was referring to what's, I guess it's colloquially known as the Insurrection Act. I don't know if that's the formal title, but there is a provision that permits the president to call out federal troops and or federalize the National Guard to restore order if there's an area in a state where the normal civil authorities are not able to maintain order. And that's what President Bush, H.W. Bush did in 1992 in the LA riots. I mean, that is exactly what the Insurrection Act exists for, is to restore order if there are riots.
And how did you react to Mr. Clark saying that's what the Insurrection Act is for?
I don't think I said anything on the phone, but I thought that I just thought that showed a lack of judgment in that, you know, if we're talking about that, we're talking about plans that we're really kind of, we're off the chart where we ought to be talking about things if that's part of the plan.
Why did you think that showed a lack of judgment?
Well, I think for the obvious reason that if your planned course of action is one that you think will or has a high likelihood of triggering riots in every major city in America, you got to be really sure about what you're doing and have no alternatives. And that was just not, and be justified 100%, 1000% know that, you know, you're rock solid in what you're doing. And that was not, in my estimation, that was not the sort of situation we were talking about.
Based on the phone call with Mr. Clark, what was your understanding of what he wanted the Department of Justice to do had he been appointed?
Well, I don't really remember specifics from the phone call. I mean, I can't say that I recall talking about the draft letter in that phone call. I know from recollections from the rest of what went on in the day, and that there was a draft letter that he had drafted that would go, I'm not even sure to whom, to someone in Georgia, and that it would be to have to inform them, I guess, that the Department of Justice thought that there were irregularities and that it justified calling a session of the legislature or having the legislature come up with an alternative slate of electors.
What did you think about the draft letter?
Well, I didn't, you know, I don't remember that much about the specifics of the draft letter because the broader situation rather than just the details of the letter were kind of driving things in my mind and driving my assessment of the situation. But I didn't think that there was something that would justify sending the letter. I didn't think there was something to back up an indication to Georgia that the federal government had actually found irregularities in the Georgia election.
Mr. Philbin, were you present at a meeting on January 3rd at the White House in the Oval Office?
Yes.
Who was at this meeting?
The president, Pat Cipollone, the White House counsel, me, Eric Hirschman, Jeff Rosen, the acting attorney general, Rich Donahue, Jeff Clark, and Steve Engel, the head of OLC at the Department of Justice.
What was your understanding of the meeting, of the purpose of the meeting?
Well, it was to address this proposal, this idea of Jeff Clark becoming acting attorney general and sending the draft letter to, I forget exactly who the addressee was, but sending the letter to Georgia to try to have an alternative slate of electors selected.
Can you describe the meeting for us?
Well, it was, I mean, it went on, it was long. I think it was well over an hour, and everyone, other than Jeff Clark, everyone was against the proposal, was against the idea of Jeff Clark becoming acting attorney general. A fair amount of the meeting consisted of primarily Rich Donahue critiquing any theories of fraud that Jeff Clark had brought up. I participated in that also to some extent, pointing out things that had been debunked. Steve Engel explained that the Office of Legal Counsel would not sign off on the draft letter. And I think it was Steve who first brought up that there would be resignations at the Department of Justice. And at the end of the meeting, the president decided that this idea was not a viable option, that it could not succeed, and decided that he would not proceed with the idea of making Jeff Clark acting attorney general.
Did any of the attendees who were not from the Department of Justice, so the attendees from the White House, did any of those people tell the president that they would resign if Jeff Clark were appointed acting attorney general?
Yes, I believe the president asked Pat Cipollone and me if we would resign, and we each said yes.
And why did you say yes?
Because it was not a course of action that I could countenance. I thought there was not a justification for it, and if the president was going to take that route, it was a sufficiently bad idea and unjustified interference with the completion of the electoral college count that I didn't want to be there in the White House any longer participating in that.
What do you mean by unjustified interference with the finalizing of the electoral count?
Well, I didn't believe that there were sufficient facts that had been developed to tell the legislature in Georgia that they should have a session or create an alternate slate of electors. I didn't think that there was any evidence of fraud that had actually affected the outcome of the election. And so trying to do something to change the electoral vote count would in itself be corrupting the outcome of the election, because we didn't have actual evidence to show the fraud that would justify taking that action.
What was the end result of the meeting?
Well, as I said, the president determined that he would not appoint Jeff Clark acting attorney general. The letter would not be sent, and that was the end of it.
I don't have any further questions.
Mr. McDougall.
Thank you, Mr. Hirsch. Mr. Philbin, good afternoon.
Good afternoon.
I'm Harry McDougall, and I represent your former colleague, Mr. Clark. Who did you discuss the letter and the possibility of Mr. Clark becoming Attorney General with before the January 3rd meeting in the Oval Office?
Certainly the idea of Jeff Clark becoming acting attorney general with Jeff Rosen and with Pat Cipollone. I don't know if before that I had really talked about that with Eric Hirschman. And the letter probably with Pat Cipollone, but I really don't specifically recall much about the letter.
All right, sir. And I think it was Mr. Cipollone that asked you to attend the meeting?
Yeah, I guess so. I mean, it was all just being planned with all of us as participants.
And the president was happy to have you as part of that discussion?
As far as I mean, he didn't object to me being there.
And he didn't object to anybody being there, did he?
None of those participants, no. In fact, at the beginning of the meeting, Rich Donahue did not come in. He was there at the White House, but he did not come in. And when the president understood that he was there, he said, "Oh, we'll bring him in, have him." So then Rich Donahue came in.
Now, did the president have a practice or tendency to let his advisors argue it out in front of him, their opposing positions?
Yes, very much so. That was the way he gathered information, tested ideas, and came to a decision on things. In fact, he would do that multiple times on the same issue. Have one debate with one set of people, then have it again with someone else in the room, and have people hash it out.
And was it the case that sometimes or even often those discussions became heated, not just in this case, but in other cases?
Yes.
Hello?
To your understanding, well, you described it, but a little bit, but what was your understanding of why the president operated in that way?
Well, I think that was the way that he liked to gather information rather than, some people like to go sit and read papers on something. Other people like to hear a debate. They like to hear things, people voicing their views and arguing it out.
And would you be of the view that he liked to see who could win the argument in front of him?
Yes, to some extent. I think that's probably true. Because it would, I think he probably viewed it as a test of, what who
barely
really has the better argument. I mean, if you can't
have more volume,
make the argument there and convince people and make it sound convincing, then
hold on.
That's probably not the better side.
Say something?
Okay.
Okay. Yeah.
And in this case,
yes.
the president did not appear to mind that it was a heated discussion.
No. In fact, I think in some ways he enjoys that. I mean, he thinks that people are
Hi, Steve. Yes, barely, but yeah,
really honest views on things if it gets a little bit heated.
If we can have more volume,
candor that you just referred to, that's something that you, for example, depended on executive privilege to be candid with the president.
Can you give me more volume on the earpiece?
Yes.
And would it be fair to say that everyone in the meeting was depending on those privileges for presidential communications in order to convey their really, really candid views of the matter?
Yes.
Say it again?
I think executive privilege is critical. And it's what ensures that the president can get really unvarnished
actually,
advice.
a Dunkin' Donuts truck came and handed out coffee and donuts.
Somebody might say about
they weren't great, but hey, it was better than
and as a result of that unvarnished
black
and heated
coffee
discussion,
I can hear you.
The president arrived at a decision that you thought was the correct decision.
Does the cameraman have what?
Yes.
Yeah, he can hear you.
The conversation that you alluded to, that you had with Mr. Clark, where you made reference to what might happen to his career, that was outside of the Oval Office. That was a phone call.
Yes.
And would it be fair to say that you were not saying that as a threat, but as a conversation with somebody you'd known a long time?
Yeah, no, I told him as a friend that I'm really concerned. Like this will be a disaster, so don't do this.
Now, I think in your direct testimony, you indicated that Mr. Clark seemed to you to be sincere in his views.
He was 100% sincere in his views.
However mistaken you thought he was.
I'm sorry?
However mistaken you thought he was.
Yes. And as I said, just to elaborate, as I said, I believe that he felt that he essentially had a duty to do it, because where you think something wrong is happening, and you are in government and you have the opportunity to do something about it. I think that is the situation that he viewed himself as being in, as seeing something happening
Say that again?
that was wrong, and he was the one who was sort of put on the spot to have the
I can hear
opportunity
you,
to do
but
something about it.
earlier I was listening and I could not hear Steve.
So would it be fair to say that he pursued what he thought was his duty despite the likelihood that it would result in the destruction of his
It's at the
career?
maximum level.
Yes.
Do you know many people with that kind of courage?
Yeah.
No, not
We'll
that
figure it
many. And I've seen a lot of people in government who don't, who are constantly trying to look at
It's cold.
how will this affect me? You know, what about my next job? How do I plan things for my next job, not just what is my obligation to do my best in this situation?
I can hear you, Steve. Just right now, I have
And
like
that is
3
somewhat
trucks
the way of Washington,
passing next
is
to
it
me,
not?
so.
some extent.
But I can hear you. I can hear you.
Now, do you know
Yes,
how
it
it
is
came to
louder
be
than
leaked to
before.
the
I
New
can hear
York
you better
Times
than
that these
before.
discussions had occurred in the Oval Office?
I don't. I mean, there was. I do know, since you asked about the executive privilege part, that the president waived privilege on this subject. I think going back to some congressional testimony that Jeff Rosen and others gave, and then there have been subsequent press reports about testimony to a grand jury.
Right, but the New York Times story about this, do you recollect that it ran right after President Biden took office, January 22nd of 21?
I don't recall the press timelines.
All right, but do you recollect or know anything about how it came to be, came to the knowledge of the New York Times when everybody in the room was subject to confidentiality obligations as professional lawyers?
I don't know.
You mentioned the prior episode in the Bush 43 administration where there was a threat of mass resignations over the terrorist surveillance program.
Cheers.
Yes.
There were arguments back and forth about that policy within the Bush administration.
Yes.
They were heated arguments.
Yes.
And the people that lost that argument, were they reported to the DC bar for attempted dishonesty?
Oh, objection, Mr. Chair.
If you know.
I'll allow him to answer if he knows.
I don't know. I know a lot of people, colleagues of mine from the Bush administration, had people file complaints about them, bar complaints for various things. Whether that specific one was, I don't know. It's quite possible for one person in particular I'm thinking of, but I don't know.
It's somewhat of a cottage industry to file bar complaints against Republican administration lawyers, isn't it?
Objection. Sorry, Madam.
Good.
Well, it is kind of argumentative. I also don't know whether the witness has a foundation to answer the question.
Do you know whether it is common for left-wing groups to file bar complaints against conservative lawyers from Republican administrations?
I won't try to characterize it as common, but it has happened in my experience on multiple occasions. When I say in my experience, I don't mean against me. Let me just clarify, but against colleagues of mine.
Good clarification, Mr.
Yeah. Is it your belief that the president or President Biden has waived executive privilege to permit you to testify as you have today?
I believe so, because I believe it's actually, can I, I'd like to if we can take a break so I can consult with my lawyer, because I don't want to say something that's not public, but I think I know it's public. There are things related to a grand jury here.
I have no objection to him huddling with his lawyer.
Mr. Chair, I would object to the question in general. It's asking for Mr. Philbin to make a legal conclusion.
Here's my problem, Mr. McDougall. It's a delay. I don't know how much more in cross-examination you have of this witness, and I'd like to get through it since we have about 15 minutes left.
Well, I've got a little more.
Excuse me?
I've got a little more. A few more pages.
I just don't see the probative value of it. So if we're going to take a break, I mean, to do it, you can get a quick answer, Mr. Philbin, in a minute, but if it's going to take a consultation, I don't want to delay everybody's time and have to hold the witness over. So, I just don't know how much more questioning you have.
Well, I will inform the chair that I prepared an outline. I am as I go, there are a lot of questions that I'm not asking. So it will be less than the length of the remaining outline, maybe 15, 20 minutes.
All right, if that's the
maybe
case.
30, somewhere in there.
If that's the case, and are you expecting to do redirect, Mr. Fox? Okay. All right, Mr. Philbin, if you can do it briefly, I would appreciate it. And just go off camera and on mute.
Yes, I will be quick.
While we're waiting with this, Mr. Fox, assuming Mr. Philbin finishes his testimony today, are we starting tomorrow with who?
I'm sorry, Mr. Hurst, I couldn't quite hear the beginning.
Assuming Mr. Philbin finishes his testimony today, who are we starting with tomorrow?
Mr. Rosen.
Mr. Rosen? Okay, thank you.
And then Counsel.
Yeah.
And then you're finished. So.
And then part of the council make depending on the council's getting part of the council.
Mr. Philbin has returned, Mr. McDougall. Okay. All right. Mr. Philbin, can you now answer the question?
Yes. So I believe that President Biden has made it clear that he would not assert executive privilege because in connection with the testimony to Congress and the grand jury testimony that I referred to earlier, the Biden administration publicly said that they believed it was not in the interest of the United States to assert executive privilege over conversations related to the January 3rd meeting of the White House.
This is the first public proceeding at which you have testified about these matters?
Yes.
In the Oval Office meeting and in your other discussions with Mr. Clark, is it fair to say that the participants disagreed about what the facts were?
I think that's true.
And that they disagreed about the significance of the facts?
Although I have to say, I don't remember specifically. So, for example, facts about Georgia, and do they disagree about specifics about facts of election fraud in Georgia? I couldn't tell you as I sit here now that I could remember a back and forth specifically about Georgia.
All right, thank you. Would it be fair to say that the parties disagreed about the significance of what was known?
Yes, I think so. Because look, there was a disagreement about whether what was known was sufficient to justify some action.
Okay, and that was going to be my next question. They disagreed about what, if anything, ought to be done in that situation.
Yes.
And in particular, about what the public stance or position of the Department of Justice ought to be on these matters.
Yes.
Apologize for the delay, Your Honor, but I'm skipping questions, so hopefully that will ameliorate your frustration with me.
I never get angry at somebody taking out a marker. So- And we've all done it. I appreciate it, Mr. McDougall.
Okay, Mr. Philbin. With reference to the White House contacts policy, that is a policy memo, correct?
Yes, to the best of my recollection.
And it is not a constitutional provision that limits those contacts?
Mr. Chair, I'm going to object to sales on the state correct.
I'll allow it.
Could you repeat the question?
Sir, it's not a constitutional provision that's the basis for limiting those contacts.
That's correct.
And it's not a statute
Correct.
or a federal regulation,
I believe that's correct.
nor a bar rule.
Yes, that's correct.
The White House contacts policy cannot limit or bind the president.
Good evening, Steve. Yes, the latest information we have was from a press conference about an hour ago where Governor Wes Moore was accompanied by Senator Ben Carr, Senator Ben Holland, even Secretary of Transportation Pete Buttigieg made his way to the Baltimore harbor. And all the authorities insisted in one thing, Steve, and it's that it's still a very search and rescue operation. The agency leading the investigation is the National Transportation Safety Board, but they've deferred to the Coast Guard and other first responders to focus on search and rescue before the investigation. But let's listen to what Jennifer Homendy, the chair of the National Transportation Safety Board, had to say earlier today. So, Steve, what we know so far is that around 1:30 in the morning, the Singaporean flagged container ship Dolly struck one of the support beams of the Francis Scott Key Bridge here in the Baltimore Harbor. causing it to collapse. The Dolly, the container ship, had lost propulsion minutes earlier. It had also issued a mayday call, a distress call, warning authorities that they had lost control. Authorities then diverted traffic away from the bridge and saving many lives. Let's listen to what the Governor Wes Moore had to say about this incident. So, Steve, this bridge was built in 1977. It was a 1.6 mile long bridge with 4 lanes, 2 in each direction. It was one of 3 main arteries crossing the Patapsco River into Baltimore City. The other 2 are tunnels. The Francis Scott Bridge, iconic for locals, is also very important for commuters coming into Baltimore. So, you know, it's going to be a long time before communities can recollect from this disaster. It will obviously affect the port of Baltimore and shipping coming in and out of this area. Yes, Steve, very interesting. Actually, the National Transportation Safety Board has not yet boarded the ship. The ship is still right there where it was when it hit the bridge, and the crew is still on board. As of now, authorities are talking about 8 people who fell into the water. 2 of them have been rescued by authorities. 1 remains in the hospital. The other man remains in contact with authorities. But it's 6 people that remain missing. 6 people, Steve, that belong to a construction crew that was working on fixing potholes on the bridge. The rescue efforts are, of course, still ongoing. Let's listen to what Fire Chief James Wallace had to say about these efforts. So, Steve, it's also very important to mention that the FBI and other government agencies have stressed that there is no information indicating terrorism, that this thus far does look to be an accident. Also, President Biden spoke earlier today promising federal funds and that he would request them from Congress in order to rebuild this bridge. Back to you, Steve.